For 5 minutes. Right? ಬಂದಿದ್ದಾರೆ.
ಕೊಡಿ. ಏನು ಅರ್ಜೆನ್ಸಿ ಏನು ಅರ್ಜೆನ್ಸಿ? Nothing will happen. Monday ಬರ್ತದೆ ಅದೆಲ್ಲ ಕಾಮನ್. ಅದು ಮಂಡ್ಯ ಅದೆಲ್ಲ ಕಾಮನ್ ಮ್ಯಾಟರ್ಸ್ ಇಲ್ಲ.
Serial number 33 to 43.
35. Consider next year Ethan. No, it will be disposed of even if you are absent. Yeah, next year Enalli Chandrasekhar idare. '28. Only thing is that that is your objection may be the outcome of your endorsement. That's all. Heard the council appealing for the petitioner and the respondent number 1 and 2, taking into consideration the fact that the petitioner has made a representation produced at Annexure E, seeking enhancement, seeking consideration, seeking compensation under 28A of the LA Act, is open for the respondent to consider the same and outcome of the same be known to the petitioner within 3 months from the receipt of this order. Accordingly, writ petition is disposed of. Next matter. That's a 28A capital A.
Serial number 44 to 47.
Disposed of. Yes. 45, madam. At the request made by yes. Yes, at the request made by the council appealing for the respondent, list after 2 weeks.
Serial number 48 to 52.
My lord, serial number 49.
1 minute. Yes, madam. 40. At 2 weeks. At the request made by the council appealing for the petition, list after 2 weeks. 48, madam.
Plus 49, my lords.
49. You are for
Hearing for respondent 2, my lords. May I request for 2 weeks time?
For the respondent number, the legal representative of the respondent number 2, list after 3 weeks. Yes.
Obliged.
Serial number 53 to 58.
Yes, sir. At the request made by the council appealing for the respondent number 3, list after 3 weeks. Inform the other side.
Serial number 59 to 64.
Yes. Yes. The request made by the council appealing for the petition, list after 3 weeks. Yes. At the request made by the council appealing for the petitioner, list after 2 weeks. List after 2 weeks. 3 weeks. Interim order granted earlier, extended till next date of the year.
Serial number 65 to 32.
That is only covered by consider. No, that is also serial number. No, that is also serial number 6. They will establish the right before you. That is also the same of, that is same of 16 and 18 also. They will produce all the necessary documents to establish their right. Even that is also serial number 16 and 17. Got to 16 and 18. No, let us will see. No, 16, 18, 71, 73. Possible it will be disposed of. No, possible disposed of. Next call, madam. Let it be there only. 67, madam. At a request made by the Lana Council appearing for the petition list after 3 weeks. Yes.
In about 73 to 76.
At the request made by the Lana Council appearing for the respondent list after 2 weeks. 75, madam. At the request made by the Lana Council appearing for the respondent list after 3 weeks.
In about 77 to 70, 77 and 79. 80 to 82. 87 to 89. Any adjustment? 91 and 92.
Monday. That's Kodi Monday. All the matters. Kodi. Yes. You have no grievance against them. Yeah. Submitted by the Lana Council appearing for the petitioner that the petition has not sought for any relief against the defendant number 2 and 6 in commercial OS number 268 of 2020. Accordingly, not arraying the defendant number 2 to 6 as party in this revision petition is dispensed with at the risk of the petitioner. Accordingly, office objection is overruled. Next week. Huh? Why? Huh? Well, Presbyterian has the officers informed to file the amended petition. Office will say withdraw. It's not the ground for you to withdraw the petition. No, you read your memo. Please read your memo. Please read memo, sir. Office has directed me to withdraw the petition. That's why we are withdrawing. Yes, inform to file amendment petition and direct the office to return so and so. See, office says something else. Don't appear. How can you say that in the memo? See, as the office has informed to file the amended petition to withdraw the present petition. That's why you are withdrawing. Huh? Lana Council appearing for the petitioners submitted that he may be permitted to withdraw the petition with liberty to file the fresh petition, urging the grounds fresh petition ಯಾವುದು ಎರಡು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ against the impugned order dated 21/7/2022 in execution petition number 44 of 22 and execution petition number 45 of 22 by the third additional civil judge and GMFC at Kadur. That way of the matter. Petition revision petition is dismissed as withdrawn with liberty as stated above. Registry is directed to return the certified copies of certified copies annexed with the petition. Yes. Huh? Maintainability. What is the order that you challenge? The family court, which order? Where is the order, sir? Which order that you challenge? Which order you challenge? ಯಾವ order challenge ಮಾಡಿದ್ದೀರಾ? 19 RPFC ಬರಲ್ಲ. WP. Sorry. The petition herein has challenged the interim order on IA number 4 by the first additional principal judge, Family Court, Bangalore, on IA number 4. That way of the matter. Revision petition. The present revision petition is not maintainable. However, liberty is reserved to the petitioner to challenge the same in the appropriate petition. Yes. Accordingly, revision petition is disposed of. Yes.
My lord, in this case, I bring the petition, my lord, not feeling will 2 weeks time may be granted my filing.
Very well.
Please, my lord.
Finally, 1 week time is granted to the.
No, my lord, 2 weeks, please, my lord.
Finally, 1 week's time is granted to the petitioner to comply with the office objection with regard to the amending the writ petition, failing which the petition shall be dismissed without reference to bench.
Please, my 2 weeks, my lord. Please, my lord.
Next matter.
2 weeks, my lord. That same, my lord.
Yes. Accepting the cause shown in the memo seeking withdrawal of the writ petition. Writ petition is disposed of as withdrawn. Yes. 2 weeks. 2 weeks time is granted to amend the WP. Yes. Okay, sir. Amended petition is served to. Then a counsel appearing for the petitioner is also permitted to serve copies of the amended petition to the Lana counsel representing the respondents. Yes. Next, interim order granted earlier, extended till next. Counsel appearing for the petitioner seeks 2 weeks time to take necessary steps insofar as unserved respondents.
Happy for the petitioner in this case, my lord. I seek for a week's accommodation.
No. It was, I think, it was submitted on the last occasion. OS and insofar as. You have to serve copy because of you non-compliant officer raised on IA number 1 of 22 direction filed by the advocate R4. Do not serve copy to him. Maybe, but it's not served copy. Then a counsel appearing for the respondent number 4 seeks 2 days time to serve copy of the petition to the Lana counsel representing the petitioner. 2:30
Next week, my lord.
Right. Just on Friday at 2:30. No,
Yes.
no, no. No, let us, we will see. By that time it will be 2:30 on Friday. Yes.
Avishkar, one minute.
Accepting the memo dated so and so, petition is dismissed as withdrawn. Yes. Disposed as withdrawn. Yes, sir. Yeah. That is required. 2 weeks, council applying for the petition seeks 2 weeks time to comply with the office objections. Yes. 2 weeks time. 2 weeks time is granted to. Yes. Yes, we comply with the office objection. Yes, 2 weeks time is granted to comply with the office objection. Yes. Whatever Mr. Chennaigoda is not appearing. So it is submitted that Sri Manu K is representing the respondent number 5. And you have filed a power. And it is also submitted that the respondent number 5 is Sri Manu K has filed power on behalf of the respondent number 5. Registry is directed to print the name of Sri Manu K in the place of Sri Chennaigoda appearing for the respondent number 4. Registry is directed to delete the name of Sri Chennaigoda, council appearing for the respondent number 5 from the card list. Yes. 2 weeks time is granted to comply with the office. Order granted earlier extended till next date of hearing.
I did like that.
2 weeks time is granted to comply. Same about 2 weeks. 2 weeks time is granted to comply with the office objections. 2 weeks time is granted to comply with the office objections.
Not serial number 13, Lord. May I not interrupt? Serial number 13, 1-3.
Yes, sir.
Lord, in this case, Lord, notice may be directed to Council for BDA and ACB.
Comply with the office objections.
But the office objection is not non-service of notice to the.
No. Copy to be served to the additional Solicitor General of India. So it has to be done, sir, actually. While complying the office objection, because.
But one is, Lord, first respondent is BDA Council. Your Lord's my name, Lord, will serve there.
Yes, sir.
And number 2 is ACB, Lord. ACB is under confusion now. But I don't know whether to copy to be served on Lokaयुक्त
Yes.
or ACB as it is, as of today.
There's no ACB now.
Not yet issued.
The council applying for the petitioner is permitted to serve copy of the writ petition to the standing council applying for the BDA, Sri K. Krishna. Accordingly, office objection raised in the petition is overruled. Yes. 2 weeks time. Same. 2 weeks time is granted to comply with the office objection. Yes, we may. Yes. So what is there actually? Nature. In this case, I think the preliminary notification and final notification is challenged. Where is the notifications? Yes. Oh, how it is vague? No, annexure is there. No, they said preliminary notification 4/1/36/2010. This is what they have challenged. Annexure A ideal. It is not. Huh? No. ಬೇರೆ petition ತಂದಿರ್ಬೇಕು. Annexure A is the notification, 4-1 notification, sir. 36/2010. I think ಬೇರೆ ಇರ್ಬೇಕು ನೋಡಿ. ಬೇರೆ ಕೇಸ್ ಪೇಪರ್ ಇರ್ಬೇಕು. Annexure A is the primary notification. 1-4. At this petition. One minute. ಬೇರೆ petition. Next 16 put 14726. Previous. Just a minute. Sure, writ of mandamus for similar audit or a direction to respond to submit. Yes, in this regard, they have made a representation to you. Annexure B1. You consider and ask for them to produce the relevant documents. So that could be done, alva. You can ask them to produce the necessary documents. There are no, here their claim is so far as 17 days there are series, you reject it. You ask for the establish their right. That could be done, alva. For that purpose, why we have to keep it? Whatever the order will be passed today will be passed even after 5 years if the petition is pending. No. You consider, ask them to establish their right over the property. So that could be done. That's all. Totally. 16, 17, 18, but there's 71, 73. I will record your objection. That okay, yes, very well. No, nothing. I will take. In this petition, in these petitions, 16, 17, the serial number 71, 70, common order. 71, 73. In these writ petitions, the petitioners have sought for writ of mandamus seeking direction to the respondent 1 and 2, claiming compensation/damages in respect of the land acquired by the respondent and as per the representation produced at Annexure B series. Heard the counsel appearing for the petitioner and the respondent. And the counsel appearing for the petitioner submitted that, though the possession of the land, possession of the part of the land belonging to the petitioners in these petitions have been taken by the respondent 1 and 2. However, the respondents have not released the compensation in favor of the petitioners. Accordingly, he sought for interference of this court by issuing writ of mandamus. Per contra, Shri K.S. Bhimayal and a counsel appearing for the respondent number 5 contended that the petitioners have to establish their right over these scheduled properties, and unless they been directed to produce the relevant documents to establish their right over the scheduled properties, there is no the representation cannot be accepted. Which is so and so another. Adralla. There B series, adralli A series. She Shauri Lananga AGA appearing for the defendant respondent number 3 and 4, submitted that there is no impediment for consideration of the representation made by the petitioners. However, nothing has been produced in the writ petition with regard to establish the right or taking possession of the property belonging to the petitioners by the by the respondents by the petitioners hearing. In that way of the matter, he sought for dismissal of the petition. Having taken note of the arguments advanced by the learned counsel appearing for the parties, a short question involved in these writ petition is with regard to the consideration of the representations produced at Annexure A series as well as the B series in some of the writ petitions. Full stop. Though the petitioners are claiming that their land has been acquired by the respondent number 5 for the purpose of the project of the Yamavati project. However, no document is forthcoming in this petition with regard to establish the right over the scheduled properties, scheduled properties in this petition. That way of the matter, I'm of the view that the petitioners, in view of the same, though these petitions referred to above are made to the respondent for consideration, it is open for the petitioners herein to make one more representation along with all the relevant documents to establish the right over the scheduled properties as well as to substantiate the contentions raised by the respondent with regard to the fact that the part of the land belonging to them has been acquired for the purpose of the Yamavati for the purpose of the Yamavati project. In that way of the matter, writ petitions are disposed of. However, this petition disposed of with a direction to the respondents to consider the representation above mentioned within the earliest period. It is also, however, it is also open for them to make one more representation with regard to the same for the as per the observation made above. Accordingly, writ petitions are disposed of. Yes. 2 weeks time is granted. What the office objection? To retain the nature number. Survey number are not forthcoming in the annexure A, B, C. Legible copy. Legible copies. 2 weeks time is granted to comply with the office objections. That's right. I think, 29-2. Okay, one more petition is there. Like, serial number? What category? I know. Not like that. I think since the notice has not been ordered, that's why. Unless the notice is ordered, so your case is only just like a caveat. That's all. Sir, no. Sorry. In these writ petitions, what is last time ಕೊಟ್ಟಿದ್ರಲ್ಲ same date. ಅದೆಯಲ್ಲ ನಮ್ಮ ಹತ್ರ ಬಿಟ್ಕೊಂಡಿದ್ದೀವಿ. ಸರ್ 1 ನಿಮಿಷ. 16240 ಅಲ್ಲ ಎರಡನ್ನು ಒಟ್ಟಿಗೆ ಕಾಮನ್ ಆರ್ಡರ್. In WP number 16240 of 2022, the petitioners have challenged the general award dated 16/7/2018 produced at Annexure A with respect to the land belonging to the petitioner bearing survey number 16, measuring to an extent of 122 square meters, situate at Ebbagodi village, Anekal Taluk, Bengaluru. In WP number 14204 of 2022. Separator. First idರಲ್ಲಿ 16240 ಅದು ಮಾತ್ರ ತಗೊಳ್ಳಿ. Third, the Lana Council appearing for the petitioner as well as the Lana Council appearing for the respondent. The grievance of the petitioner in this case is with regard to the claim made by the petitioner for dispersal of the compensation as per the consent agreement under section 29 class 2 of the Karnataka KIE, Karnataka Industries So Act, KIDB Act, within bracket referred to as Act. Full stop. It is submitted by Lana Council appearing for the petitioner that similar petitions have been disposed of by this court in WP number 13463 of 2022 on 15th July 2022, and similar orders be passed with respect to the scheduled properties mentioned in the writ petition. So in that way of the matter, as the scheduled lands have been acquired by the respondent board for the purpose of metro, both are metro, for the respondent number, for the benefit of respondent number 4, there is no impediment for the respondent KDB to consider the case of the petitioners under section 29(2) of the Act. In view of the above, I pass the following order. The petition is allowed. 1. The general award dated 16/7/2018 produced at Annexure A, is passed by the third respondent at Annexure A is insofar as the property belonging to petitioner is hereby quashed. Next one, respondent KDB is directed to respondent number 3 is directed to consider the case of the petitioner in terms of section 29 class 2 of the Act upon the petitioner satisfying all the requirements thereof. Next one, in the event of there being any claims adverse as regards the petitioner in respect of the said lands prior to the dispersal of the amount, the general award will be revived automatically. Next, 5th one. Respondent number 3 is permitted to withdraw the amount in deposit in respect of the subject land and disperse to the petitioner in terms of the observation made. Same. ಇದರಲ್ಲಿ ಪಾಲಾಕ್ಷ number 1, Sri PV Chandrasekhar for 2 and 3, K Krishna for all. Same thing in other petition. Same order. Only survey number land matter. Yes. Complaints of officer. Even otherwise, it's a principle. It's a principle in my court. Unless the office objection is complied with, even otherwise. Yes, you can. You can do it and I will take it. Because otherwise, I will. It amounts to discriminating others also. It is a principle that office objection will be complied. If any, it will take about 2:30. Very good. See to that it will be done. Don't mistake me. Sorry. It's a principle unless the promise. Otherwise, what will happen? Every alternative, the senior advocates will then be forced to do, and it will discriminate others. That's very well. It will be complied with. I will take it up to 2:30. Yes. Amendment filed by the advocate for petition. Just 1 minute. Just 1 minute. Just a minute. What is challenge in this? Just a minute. What is the amendment to sorts? What is the amendment sorts? Annexure application. Imbara. Land was yes. Sir. Only is the beneficiary of the land. No, is the respondent number 2. Madhuvana. There are number of petitions are pending like this. It is pending. You file objection. Only thing is, whether the beneficiary of the land has been made before the reference. One, just I will. Government advocate cannot represent a Madhuvana house in cooperative society. Just a minute. Just a minute. Just a minute. No. Many petitions are. Lana council appealing for the respondent seeks 2 weeks time to file objection. Yes. So, division bench judgment is at the very same point. That appear in such pattern. Division bench start from word P actually. Division bench. All right. Division bench judgment is there. Writ petition is made. No. That's a different case. Here, you have not been heard. No, they are aware. This is this. Let us no division bench. It is no division bench. I told you. There's this matter in B group after 2 weeks. Yes. Let us will see. Let us will see. No, let it be considered after 2 weeks. Nothing else. Yes, it will be done.
23.
Memo filed by the advocate petitions. Say the affidavit. Yes. No representation. No representation on behalf of the petitioner. No representation on behalf of the petitioner. Just after 2 weeks. Just after 2 weeks. I didn't. I think it was listed on the. Yes, sir. Yes. Correct. I think as of now, you are not the owner of the property. Huh? I think it was here. Yes. Yes. Pleading applicant. Just 1 minute. It's changed. That's the only thing. The second petition you can see. So only thing is, sir, can withdraw petition and make one more petition, one more representation. Yes. Yes, sir. So you're not made any application. The next paragraph 19. Never invoke 14A according to them. No. Now, whether the original petition made an application or not. Where is that? Where is that? Correct. Page 46. Just 1 minute. There's a petition number 2. Yes, sir. ಬೆಂಗಳೂರು ಭೀಮನಕೊಪ್ಪ ಎಕರೆ ಜಮೀನನ್ನು ಭೂ ಉಪಯೋಗ ಬದಲಾವಣೆ ಮಾಡುವ ಬಗ್ಗೆ ಪತ್ರಿಕಾಪಟ್ಟಿಯನ್ನು ಹೊರಡಿಸಲು ಕ್ರಮವಹಿಸಿದೆ. ಅದೇ 14A. That itself is a 14A. So you withdraw and file one more application. That is best. In this petition, it cannot. In this petition, relief cannot be granted. Full stop. Ardilana counsel appearing for the parties. Shri K. Krishna Lana counsel appearing for the respondent number 1 and 2. Raise preliminary objection with regard to the fact that the original application has been made by the vendor of the petition number 2. Allah? Impleading who is to the yes, impleading applicant, impleading proposed applicant, petitioner, and in that way of the matter, the writ petition does not survive for consideration. They said submission was resisted by Sri K. Hanumantarayappa and a counsel appearing for the respondent, appearing for the petitioner, inviting the attention of the court to the paragraph 19 of the writ petition. The list of She so and so and her AGA also supports the contention that the writ petition does not survive for consideration as the consideration of the application made by the original petitioner under section 14A of the Karnataka Town and Country Planning Act 1961 cannot be considered. So in the light of the submission made by the Lana Council appearing for the process, I have carefully considered the impugned letter dated 9/10/2015 issued by within bracket annexure H issued by the respondent number 1 and 2. It is also not disputed by the parties that the petitioners herein are no longer the owners of the properties in question, and in that way of the matter, I am of the view that the writ petition does not survive for consideration. However, it is open for the now the impleading applicant. Now it is open for the impleading applicant / the purchaser of the land in question from the petition's hearing liberty is reserved to the impleading applicant to make application for seeking change of use of land if so advised. Purchasers is open for them to make an application if so advised. Yes. So accordingly, writ petition is disposed. Yes. For impleading filed by.
I pay for respondent
Yes,
number 2 and 3 also.
Who has filed this? Whom do you want to? Two weeks. Then a council appearing for the petition seeks 1 week's time to comply with the observations. Yes.
But I appear for the petitioner, my lord, in this case.
Shamantik Naik, yes. Sorry. Then a council, you will file an objection letter.
Please, my lord, please.
Then a council appearing for the respondent 2 and 3. 2 and 3 seeks 2 weeks time to file a statement of objection finally. Full stop. So time is granted. Next one, registry is directed to delete the name of Srimati B.A. Sujata appearing for the respondent number 2 and 3, and to retain the name of Sri B.A. Sachin, Lennox Council representing the respondent number 2 and 3. What of the acceptance? Full stop. Cost of rupees 1,000 paid is accepted. Be accepted. Yes.
Great.
27, I appear for the petitioner, my lord. A date may be
Yes.
fixed for hearing, my lord.
What is this?
Preferably 6th September. ಬೇರೆ ಕೇಸ್ ಹೋದ್ರಲ್ಲಿ ಡೇಟ್ ಮೇ ಪೋಸ್ಟಿಂಗ್ ಅಯ್ಯ ಹಾಕಿದ್ದೆ ನಾನು ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್
Yes, sir.
ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ಡ್ ಫಾರ್ ಹಿಯರಿಂಗ್.
1 minute. 1 minute. Yes, sir. So it may be taken up later also. After 2 weeks also.
ಅಲ್ಲ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಲಿ ಸರ್.
List after at the request made by the Lana Council appearing for the petitioner. List after 2 weeks accordingly year 2 of 22 is allowed.
ಅಲ್ಲ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಲಿ ಸರ್. ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಲಿ. 2 weeks ಅಂದ್ರೆ ಅದು ಬರೋದೇ ಇಲ್ಲ ಮತ್ತೆ. ಅಲ್ಲ ಒಂದು 6 ಸೆಪ್ಟೆಂಬರ್ ಗೆ ಒಂದು ಅಲ್ಲ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್.
Yes, sir. 12th, sir. 12th September.
12th September.
Yes, sir. Just 1 minute. 2010 is objections is filed. Get ready. Huh? Get ready. B group ತಗೋಬೋದಲ್ಲ. Or the Lana Council appearing for the parties on IA 1 of 22 and same is allowed. This matter for B group on 15 days. Yes. Listing day.
29 case.
Yes, sir. Then a council appearing for the petition seeks 2 weeks time to file rejoinder. Time is granted. Yes. So,
Lord, in cell number 30, I appear for respondent for the first matter.
Any urgencies? Okay. Let us will see. So one day we will take it up. Next week it will be taken as a final discourse. Better. You entered appearance. You filed power. You filed power also. For which petitions? Sorry. So registry is directed to print the name of so and so as is representing the petitioners in WP number 1108022021. Next week, one date for 2:30 we will take it. Huh? You file it 1 week, 2014 matter. Cannot be. 5th at 2:30. 2:30 means it will be taken up on. No, 2:30, sir. It will be taken.
31.
Yes, but the notice has to go. Whom do you want to implead?
My lord, I appear for respond number 3 to 5 in this matter.
Wait. So whom do you want to implead now? But even application.
My lord, I want to make one submission with regard to impleading. My lord, what they are saying that they want to implead Union of India Ministry for direction them to acquire land. My lord, first, my lord, this court has to, like, they have to establish that land has been acquired or utilized. So,
What is
not necessary party
impleading
NHI.
them is does not. Let them will implead, madam. Others.
NHI is here, Metro is also here, my lord.
Are the Lana Council appealing for the parties? The petitioner wants to implead the Union of India, Ministry of Shipping, Road Transport and Highways, Department of Road Transport and Highways, New Delhi, considering the governments made in the affidavit accompanying the application, IA 3 of 22 is allowed. Lana Council appealing for the petition is permitted to amend the cause title. In the meanwhile, Lana Council appealing for the petition is permitted to serve copy of the petition to the Lana Council MN Kumar CGC, Central Government Council. MN Kumar Swans CGC appearing for the which respondent now after 7. It will be taken. You file amended cost. Yes. Yes. No date. Date kotirada. Yes, please. You move it immediately.
Serial number 32 ಮಲ್ಲ ಇದನ್ನು ಕೂಡ 12ಕ್ಕೆ ಫಿಕ್ಸ್ ಮಾಡಿ ಸ್ವಾಮಿ. ಸೇಮ್ ಡೇಟ್ 32.
Who has to consider your representation?
No, posting ಅಯ್ಯ ಹಾಕಿದೆ ನಾನು.
Who has to consider, sir?
The representation has to be considered by Milord.
Mr. So and so, except notice for.
Notice ಆಗಿದೆ ಇದರಲ್ಲಿ. Notice ಆಗಿದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
Respondent number 12.
Notice ಆಗಿದೆ ಇದರಲ್ಲಿ.
125.
Notice ಆಗಿದೆ ಸ್ವಾಮಿ. Notice ಆಗಿದೆ ಇದರಲ್ಲಿ.
Government ಇದಾಗಿದೆ. AGA has to appear for the state of Karnataka. Someone has filed wakalat.
Notice ಆಗಿದೆ.
Only consideration of representation will be done. Or the Lana Council appealing for the parties. The grievance of the petitioner in this petition that the land belonging to the petitioner has been utilized for the construction of approach road to the railway overbridge at Pandavpura railway station. In this regard, the petitions have made representation dated 29/7/2020, Annexure yes, and sought for award in respect of the acquisition of land made by the respondent authorities. In that way of the matter, if the land belonging to the petitioner is acquired for the said purpose, the petitioner is entitled for compensation under law. That way of the matter, I have to view that there is no impediment for the respondent. Which respondent have to consider? Sir? That way of the matter, the respondent number 6 is directed to consider the representation produced at annexure yes dated 29/7/2020 within 3 months from the receipt of this order. This also made clear that this court has not expressed any opinion on the merits of this. Yes.
Within 3 months, my lord, to consider this.
Yes. Yes.
Obliging.
Good. This petition is filed under section 24 of CPC, seeking transfer of MC number 78 of 2021 filed by the respondent before the senior civil judge and GMFC at Chennai. Third, the council appearing for the parties, taking into consideration the fact that the petition is having 2 years old child and she is facing the monetary life. She is facing financial crisis as stated at paragraph 15 of the petition. I am of the view that the hardship would be caused to the petitioner to attend the proceedings at Sira, at the competent court at Sira. Accordingly, the petition deserves to be allowed. Full stop. The MC number 78 of 2021 pending consideration before the senior civil judge and GMFC Sira is withdrawn and transferred to the senior civil judge and GMFC court at Chennai. Yes. Accordingly, petition is allowed. Yes. Yes, sir. Huh. 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 Yes. Yes. What is the relief sought for? Relief sought for in the plaint. Yes. Permanent and restrained dependence property in NTP is absolute owner. Declaratory suit. Yes. I know, that's correct. 226 only. What is the plaint hour means? Say that it is not binding on the plaint. Maybe. Yes, sir. That's correct, sir. And if you look at paragraph 7 of the plaint, it is stated that right. Where is the law on the point? What is the law on the point? Leave of the court ತಗೋಬೇಕು ಎಲ್ಲಿದೆ? ಎಲ್ಲಿ? ಎಲ್ಲಿದೆ ಅದು? There's no law. I think it is seeking one more. Yes, it's declaration, and also is saying that the fraud, and also an element, and also the element of fraud is yes. Then why do you worry? Go for trial. Then why do you worry? Then but in the said decree, the petitioner is not a party in this. Only parties if the event if they stated. Yes, even the separate suit may be filed. No, that's a judgment. Need not be. Kodi, how long? No. And also the suit is of the year 2015, belated stage you filed. Okay, it may be taken into consideration, but the averment made in the plaint is that she's the plaintiff is not a party in the said. If the plaintiff is a party in the said suit, your submission is correct. No. ಇಲ್ಲ ಯಾರು ಇಲ್ಲ ಯಾವತ್ತ 2:30 Monday same order. Then a counsel appearing for the petitioner seeks time to produce the relevant judgments relating to the judgments. Full stop. Monday 2:30 though. Monday 2:30. Yes, sir. Just 1 minute. Who is interfering with you? Who is interfering with you? Huh? Who is interfering with you? Sir, who is interfering with your property? Nobody is withdrawing. Nobody is withdrawing. Nobody is interfering with you. Who is demolishing? Which respondent is demolishing? Huh? 7. Property of utilization. Widening of the road. Yes. Who is representing? I know 1 to 4. I know. What about the? That's all. Yes, that. Yes. Totally. Heard the Lana counsel appearing for the petitioner and then Mr. So-and-so and AGA for the respondent number 1 to 4. Please stop. The apprehension of the petitioner in this petition is with regard to the fact that the respondents are interfering with the scheduled properties belonging to the petitioner for the purpose of widening of the road of Hale Bidi Road, Ward number 6 and 7 within the Talakadu Grama Panchayat. Full stop. Having taken note of the grounds urged in the writ petition and the arguments advanced by the Lana counsel appearing for the parties, I'm of the view that in the event if the land belonging to the petitioner is to be acquired by the respondent authorities and same has to be done following the following the due process of law. That way of the matter, writ petition is disposed of. It is also made clear that it is open for the petitioner. It's open for the petitioner to make representation to the competent authorities to seek redressal of his grievance. If such an application / representation is made, same shall be considered by the responding authorities in accordance with law. Yes. Accordingly, writ petition is disposed of. Similar petitions, G. Lakshmi Rao is, you take notice on him. Nothing else. G. Lakshmi accept notice for respondent 1 and 2. You serve copy, it will be taken up. But at this stage, it cannot be. Notice, in addition to that, petition is permitted to serve copy to Mr. G. Lakshmi and a counsel representing the PD. Yes. Yes. P. Ramesh. Yarilvalla. It's not represented. No representation. Let us visit. No representation on behalf of the petitioner. Just after 2 weeks. Good evening. Notice. 1 to Leonard AG accept notice for 1 to 4. Emergent notice to respond number 5. Not done. Let us will see. Serve it and move when as soon as the service is complete. Notice and stay as prayed for. Notice and stay as prayed for. ಇದು ಕವರ್ಡ್ ಆಗುತ್ತಲ್ಲ? That's it may be all. Yes. Leonard AG accept notice for respond number 1. SC Shivaram accept notice for respond number 2 and 3. Heard the Leonard counsel appearing for the parties. It is the grievance of the petitioners that the land belonging to the petitioners, bearing survey number 206, measuring 3 hectares, 4 guntas of land, situated at Lalitadripura village, Mysore Taluk and district, was notified as per preliminary notification dated 13/12/2006 within bracket annexure A under section 17(1) of the Karnataka Urban Development Authority Act 1987. Full stop. It is stated that this court in identical cases, in identical writ petitions, in WP number 29288-89 of 2019, dated 12th July 2019, in bracket annexure C1, quashed the impugned preliminary notification dated 13/12/2006 in respect 13/12/2006. Following the law declared by this court referred to above, the present writ petition is allowed, preliminary notification dated 13/12/2006 insofar as the land belonging to the petitioner is quashed. Insofar is quashed, accordingly writ petition is disposed of. Yes. Good evening. Yes. Not to discuss. So 222 alla order. Union of India. I think M.N. Kumar. M.N. Kumar. Sorry, Mr. M.N. Kumar CGC accept notice for respondent number 1. 2 and 3, I think. Yara Perakar, National Highways. Huh? Shilpa Shah accept notice for respondent number 2 and 3. Stop. Taking into consideration the arguments advanced by the Lana Council of for the petitioner and the grounds urged in the petition, I am of the view that the respondent, the petitioner should not be dispossessed from the scheduled property till the next date of the hearing.
Thank you, madam. There are about 44.
Yes, sir. Punjal or itra line. Yes, sir. Non-filing of report by Venkat Raman Associates. Order sheet. Has to be filed. Just a minute. Just both the councils of Venkat Raman Associates can be appointed as architect. So report is yet to be received. Sir. So that is relating to the setbacks. Both the council submits that. Order is both the council submits. Both the council submits are so and so, they can be appointed as an architect. Both of you should. No, you agreed for this. You make an application to recall this order. Await report by Sri Venkatraman Associates Architects in terms of the order dated 15/7/2022. Both the parties are liable to make good the fees to be payable to the architects. Yes, where is that? Yes, sir. Where is that, sir? Architect fees for the above shall be made payment by the petitioner. It's already made. Sir, this court long back await service of notice. Sir, you make an application to recall the old order. Unless that, I cannot make any further order. Not background, only to today's matter. Await service of notice. Yes. Not proposal. You make a await service of report by Venkatraman Associates as per 15/7/2022. Parties to comply with the same. Yes. Yes, madam. Yes, nothing else. Yes. List after 3 weeks. List after 3 weeks. 46. Ms. Charati. Objections ready? Who is the contestant party? One minute. Yes, sir. What is the challenge, sir, in this endorsement? Annexure, yes, T, yes, sir. Yes, what has happened? What is the endorsement? Why? For you, it is conditional grant. Annexure? What is the conditions? Annexure A. Yes, correct. Then how did you entitle for? Really? But he has no more ever. Yes. Which is will surrender whenever required by the government without claiming compensation. Required by government without claiming government.
Even though petition include
Grants are granted by government. Government. Grantee shall surrender the land to the government without claiming any compensation. Without claiming any compensation. But the government, without exercising the power reserved by the land, the government has to pay the compensation for the use of the land. Yes, what do you say? What do you say? That's right. Surprise was given. For the latest law. So, at the request made by the Lana Council appearing for the respondent number 2 and 3. Yeah, to list after 2 weeks. Yeah? No, list after 2 weeks. Chandrakant or party. ಮುಂದೆ ತಗೊಳ್ಳೋಣ ಅಷ್ಟೇ. He is busy, but you can argue it is you argue every time. You cannot say that. Otherwise, yes. Except for the compensation. Oh, that's it. 2:30 on dinner. First September at 2:30. Yes, at 2:30. No, it will be taken. 2:30 means it will be taken up. $48, I think. 49 at time. They took time, I think. Let us see. We will see. I will put the date. Also. Yes, double. $29 2. Yes, Chandrasekhar. 29 2. There's a dispute. There's a dispute between them. That they. Yes. That is not a question. If both of you agree, 29 2. That's. Yes. Correct. Told him. You see, that. No, withdrawn. No, that is a law. Let us switch. Yes. Told you. Yes, definitely. Detailed order. I know. No. Very good. Just a minute. Answer phone. Just to be released. No, one more will. By the time I will look it. No. Please sit down, sir. Yes. Just a just Richmond and Barrel. In this petition, petitioners have assailing the preliminary notification dated 1/12/2009 within bracket annexure D and the final notification dated 23/7/2009 passed by the respondent KIADB under the provisions of the KIADB Act 1966 within bracket hereinafter referred to as Act. The factual the relevant facts for adjudication of this. And also they have challenged. Annexure E is the award. The petitioners have also challenged the award passed by the respondent KIADB Where is that award, sir? Award. Yes, the 22 award challenge. The award dated 20th 12 2013, produced at Annexure G, comma. The relevant facts for the adjudication of this petition are that the petitioner claims to be the owner of the land bearing survey number 2/4 to an extent of 38 guntas, comma, in survey number 2/6 to an extent of 5 acres 23 guntas, comma, in survey number 3/3 to an extent of 1 acre 36 guntas, and in survey number 31/1 to an extent of 2 acre 20 guntas, situate at Tippada Dasarahalli village, Tumkur Taluk and district. It is further aware that, comma, the respondent number 4 herein has filed OS number 16 of 2011 before the second additional senior civil judge and GMFC at Tumkur, seeking allotment or seeking share in the scheduled properties, and the said suit is decreed on 13/7/2018 within bracket Annexure F. Being agreed by the same, comma, the petitioner's hearing. Being agreed by the same, the petitioner's hearing and the respondent number 4 have filed RFA number 21 of 16 18 before this court, and these appeals and these first appeals are pending consideration before this court. In the meanwhile, comma, the grievance of the petitioner is that the respondent KIDB has issued preliminary notification under section 28 clause 1 of the Act, comma, and sought to acquire a property for industrial purpose. The respondent KIDB has also issued the final notification under section 28(4) of the Act on 23/7/2009, and same is produced at Annexure T and E respectively. In the meanwhile, the respondent BDA has passed a general award dated 20th/12/2000. BDA, sorry, KDB has issued the general award. Okay, Krishna Rodi, general award dated 20th/12/2013 as per Annexure G. Annexure G. Full stop. Full stop. The further awardment made in the petitioner that no award notice was served on the petitioners. However, the petitioner is willing to enter into an agreement with the respondent KIADB under section 29 clause 2 of the Act for determination of compensation by consent. And accordingly, the present writ petition is filed. I heard so and so on a counsel appearing for the petitioner, so and so for the petitioner, and Leonard AGA for the respondent number 1. She PV Chandrasekhar and a counsel appearing for the respondent KIADB. She PM Sidmalappal and a counsel appearing for the respondent number 4. Mr. So and so and a counsel appearing for the petitioner contended that, the petitioners claims to be the owner in possession of the scheduled property mentioned in the writ petition, whereby the respondent KDB has acquired the same, and the petitioners are willing to enter into an agreement with the respondent KDB under section 29 clause 2 of the Act, and accordingly the writ petition be disposed of, quashing the general award made with regard to the scheduled properties and allowing the petitioners to enter into an agreement with the respondent KDB under section 29 clause 2 of the Act. Per contra, Sidmalappal and a counsel appearing for the contesting respondent, submitted that as the respondent number 4 has filed OS number 16 of 2011 before the trial court seeking the relief of partition and separate possession in respect of the property. And the subject matter of the property which had been acquired by the respondent authorities is also the subject matter in the suit, which came to be decreed on 13/7/2018. And thereafter, the RFA number 2101 of 2018 and RFA number 1617 of 2018 are pending consideration before this court. And therefore, the respondent number 4 opposed the contentions raised by the Lana Council appearing for the petitioners. Full stop. P. V. Chandrasekhar Lana Council appearing for the petitioner contended that for the respondent board contended that since the dispute with regard to the title of the property in question in the appeals referred to above, there is no impediment for the respondent KADB to disperse the compensation under section 29 clause 2 of the act, provided the petitioners and the respondent number 4 agreed unilaterally for the same. The said submission was also supported by the learned EGA appearing for the respondent number 1. Having considered the observation, having considered the arguments advanced by the Lana Council appearing for the parties, it is not in dispute that the land belonging to the petitioner and the respondent number 4, subject to the outcome of the appeals pending consideration before this court, is acquired by the respondent board under section 28(1) of the act on 4/12/2009, and final notification was issued under section 28 clause 4 of the act on 23/7/2009 as per Annexure D and E. The grievance of the petitioner in this writ petition is that he is willing to enter into an agreement with the respondent KDB under section 29 clause 2 of the act. However, taking into consideration the fact that the respondent number 4 herein is also contended that he is entitled for that the respondent number 4 is also entitled for share in the subject matter of the land. I am of the view that in identical case, it may be in identical I am of the view as the petitioners as well as the respondent number 4 have unilaterally submitted that they have no objection to enter into an agreement with the respondent KDB under section 29 clause 2 of the act, and same be subject to the outcome of the judgment and decree that may be passed in RFA number 2101 of 2018 and RFA number 1617 of 2018. In that way of the matter, as the petitioners and the respondent number 4, I have resolved to enter into an agreement with the respondent board under section 29 clause 2 of the act, it is subject to the observation made above. I am of the view that the writ petition be disposed of with the following subject to following order. Full stop. General 1 writ petition. Full stop. General award dated 20th/12/2013, produced at Annexure G, passed by the third respondent board, is quashed with regard to the scheduled properties mentioned in the writ petition. Full stop. 2. Full stop. Petitioners and the fourth respondent, are directed to first the respondent number 3 KDB is directed to withdraw the amount deposited before the civil court with respect to the subject land pursuant to the general award passed therein on 20th/12/2013 within bracket Annexure G. Full stop. The petitioner and petitioners and the fourth respondent herein are directed to appear before the respondent number 3. Respondent number 3, Special Land Acquisition Officer KDB on after 2 weeks for 28. 2 weeks. Yes, sir. Yes, sir. 12th, sir. 12th September 22 at 3 p.m. and put forth their respective claims before the respondent KIGB. Respondent number 3, list of. In the event, the petitioners and the respondent number 4 amicably settle the dispute between themselves and jointly intimate the same to the respondent KIDB respondent number 3, the respondent number 3 shall proceed to pass the consent award as contemplated under section 29 clause 2 of the Act. Stop. Next, in the event no such settlement is arrived at between the petitioners and the respondent number 4, respondent number 3 KADB shall refer the dispute to the civil court. To the civil court under section 30 and 31 of the is a dispute, is arrived at between the so and so. If no settlements have arrived, the original award revived. And in the event, yes, sir. Yes, sir. If the petitioner and if the petitioners and the respondent number 4 shall not seek any further enhancement of compensation on the package amount, which would be deposited by the special land acquisition of the KAD by the third respondent herein, same be deposited in the civil court. Where same be deposited. Same be deposited in before the reference court in terms of the settlement that may be arrived between all the 3 parties. All the 3 parties, including the respondent KD.
Sir, the KDP has already passed award,
No, in the event. Withdraw. Yes, yes. If such being the case, the respondent number 3 KDB is directed to withdraw the amount deposited before the civil court pursuant to the general award dated 28/12/2013, produced at annexure G, and deposit the consent. Where to deposit? Before the reference code, that's all. Before the reference code. No, that is only outcome of that proceedings. So that cannot be, that cannot be foreseen now. That cannot be foreseen now. Anyway, they are appearing before the court, you take proper action. Yes, that's all. Reference code, yes. Accordingly, writ petition is disposed of. Thus, I cannot foresee what will happen there. See, that may be done. That may be done pursuant to their meeting. Yes, that can be done only. Yes. Yes. Yes.
Appearing for the petitioner, my lord.
I appear for the counsel for respondent number 4, my lords.
Yes, just. What is challenge?
Acquisition proceedings are challenged, my lord, in the writ.
All for repercussions. Validity is challenge, sir?
No, it is given up now, my lord. It has been given up now.
Well, only thing is, it has to be considered only the notification challenge in these petitions are correct or not. Yes, sir. Yes, sir. Argue.
Lord, yes, Lord. Lord, land survey number 49 measuring 3 acres, 38 guntas.
Just a minute. Objection? Monday. You file it by Monday. So you will file the objection by Monday.
Lord, his right is already forfeited. The right to file objection is forfeited by the previous order of this honorable court.
1 minute. Now we cannot. Even otherwise, first of all, recovery from the MD. That is, then yes. Yes, sir. So already order is passed long back.
Yes.
Yes, sir. So till then now the order is not passed. Yes, sir. You argued that. In the event if permissible, if it is required, then I will grant you. Yes. The senior counsel will argue the matter. The event if request, I will grant you time. Then it will be taken up on Monday. Yes, sir.
My Lord, land survey number 49.
49.
Yes, my Lord, 3 acres, 38 guntas. And my Lord, survey number 88/1 measuring 34 guntas.
Yes, sir.
Of Mogarahalli village, my Lord, in Srirangapatana Taluk, my Lord, is the subject matter of accusation.
Yes, sir. Yes.
Lord, preliminary notification, my Lord, is issued, my Lord, on 7/1. 7/12. 7/12.
7/12.
Yes. 7/12/2005, my Lord.
2005. Preliminary notification.
This my Lord, final notification, my Lord, was also issued on 31/8/2006, my Lord. 2006, my Lord.
2006.
Yes.
31/8.
This final, yes, my Lord. This final notification was quashed by this honorable court, my Lord.
Final
On
notification is quashed.
Yes, 8/1/2016. 8/1/2016, my Lord. I produced copy of
in
yes.
WP number.
WP number, my Lord. Annexure D, my Lord. Annexure D, my Lord. Kindly be seen, my Lord.
Annexure D. 1 minute, sir. 1 minute.
Yes. Page 129, my Lord.
Annexure D.
109, my Lord.
Very same. 31/8.
Yes.
Just 1 minute.
129, my Lord, is the relevant.
Final notification is quashed. Yes, sir. WP number.
They were directed to, my Lord, consider our objection, my Lord, and pass an appropriate order, my Lord, after considering the objection.
Yes.
And again, once again, my Lord, the final notification was passed, my Lord, on 29/12/2018 as per Annexure G, my Lord.
29?
29/12, my Lord, 29th December 2018. My Lords will find it Annexure G, my Lords.
29/12/2018.
Yes.
Sir, Annexure?
G, my Lord, 166, page 166.
166. Yes. Yes, sir.
My lord, once again, my lord, we approach this honorable court, my lord, in writ petition 49,903, my lord, saying, my lord, that objection was not considered. And this honorable court passed an order, my lord, on 8/7/2019.
Where is that, sir? Where is that?
Annexure N, my lord, page 214, my lord.
214.
Yes, 214, my lord. 214.
Four nine zero three nine seven
Yes.
8/7/2019.
Yes.
Yes, sir.
Kindly see, my lord, this is how, my lord, they have misread the order, saying
Yes.
that, my lord, objections are to be considered once again. They think that, my lord, the authorities think that final notification is not quashed. Therefore, it holds the field.
Yes,
And
what happened thereafter?
thereafter, my lord, annexure Q is passed.
Annexure Q. That is the issued order.
Yes, that is the
22/8/2019.
Yes,
sir.
The authorities think, my lord, that this honorable court has not quashed the order. It has only directed to consider the representation. I have considered the representation. It has been rejected. This is how, my lord, they treat the order of this honorable court. And this is the order passed. My lord, our specific contention, my lord, before this honorable court, my lord, in this writ petition, as well as, my lord, before the land acquisition officer is, the land is converted much prior to the acquisition of the land in question.
Yes, sir. Land was converted.
Land in question was converted
Yes.
for residential purpose, my lord. All these petitioners, my lord, are the employees of Vikranta Tires, my lord. They wanted to, my lord, form a residential layout for themselves. They
Yes.
purchased this land, my lord, got it converted, my lord, into sites. And each one of the petitioner before my lords are holding, my lord, a portion of, my lord, the sites formed in that land. My lord, this was in the year, my lord, 25/3/1991. 25th March 1991, my lord, conversion order at annexure A, my lord.
1991.
Yes.
Yes.
My lords have already noted, my lord, the 3-1 notification is 7 December 2005.
Yes.
Now I am relying on a judge, my lord, on a circular issued by the state government, my lord, at annexure K, my lord, 187.
187.
Yes. My entire thrust of the argument is, my lord, on the basis of this annexure, my lord, K at 187, my lord.
185. Yes,
My lord, it is 185, my lord, Kannada version, my lord. Translated, my lord, my lords will find, my lord, at the next 187, my lord. The first portion of the circular, my lord, speaks of not to include the land in question.
Yes.
Not to include the converted land, my lord, while acquiring the land. Even if it is included, they are required to delete, my lord, the land acquired.
Yes.
My lords will find, my lord, clause number 4, my lord.
4.
Next page, my lord.
ಅನುಮತಿ ನೀಡಿರುವ ಜಮೀನುಗಳನ್ನು ಹೊರತುಪಡಿಸಿ.
Yes, sir. Therefore, my lord, placing reliance on this, my lord, we contended before the land acquisition officer to exclude this land from acquisition.
Yes, sir.
As a matter of fact, my lord, there were some other piece of land, my lord, which are covered under this notification. There were graveyards, my lord, in some some portion of the land which is subject matter of acquisition. They have accepted, my lord, and deleted, my lord, those land from acquisition, my lord, following this circular. I produced, my lord, by way of an additional document, my lord, before my lords, to show that, my lord, the KDB is...
Probably there won't be any allottees for such lands, for grave land.
Yes.
Yes, sir. Then.
Maybe, my lord, the beneficiary, that ultimate beneficiary, not the beneficiary is KDB, ultimate beneficiary, my lord, of Wipro. They said,
Yes,
I do not want grave land. Therefore,
Yes,
my lord, they might have, as your lordships have said, my lord, maybe they are not interested in the grave land. Therefore, my lord, they were given alternate land. They were given alternate land, my lord, to the Wipro.
Yes, sir.
And that piece of land was, my lord, deleted.
Yes, sir.
As far as, my lord, our request for deleting this, my lord, they are all poor laborers, and they would like to construct the, my lord, houses, my lord, which they have found for. The factory has failed to provide them a shelter, my lord. They have pooled money for themselves, my lord, and purchased this land, formed a layout, and they would like to construct the house and have a shelter for themselves.
Yes.
In pursuance of this circular, we made a request. Now kindly see, my lord, annexure Q, my lord.
Annexure Q.
Annexure Q, my lord, that is the consideration.
Yes, sir. Yes, sir.
Our written argument, my lord, have been extracted by the order, my lord, in the impugned, my lord, order. The operative portion, your lordship will kindly see, my lord, at the last page, my lord, 256, my lord.
224. Oh, yes, sir. Yes, sir.
In the middle of the paragraph, my lord, since the final notification is there.
Which page?
Last page of the impugned order, my lord, 256.
Last page of the impugned order. Yes.
Yes. And the last page of the writ petition compiled. Yes, 256, my lord. Yes,
yes, sir.
Last, somewhere in the...
Yes, sir.
After paragraph 18, my lord.
Yes.
In the middle of the paragraph, my lord.
Yes.
ಸಪ್ತಾಂಶಗಳಿಂದ ಕೂಡಿದ್ದರೂ ಅಂತಿಮ ಅಧಿಸೂಚನೆಯು ಜಮೀನಾಗಿರುವುದರಿಂದ 3 lines, my lord.
Yes, sir.
Now the whole tenor of, my lord, the contention of the land acquisition officer is High Court has not set aside the final notification. It may be a fact that there is a layout. It may be a fact that there is a circular. Land is converted. But since the final notification is not passed by the High Court, I am only required to consider your objection. I have considered your objection and rejected. Now, yes, my lords will kindly see the order passed by this honorable court, my lord. That is, my lord, the previous annexure G, my lord, at 166, my lords.
166.
Yes.
166 is the 28-4 order.
Yes. I'm sorry, my lord. 214, my lord.
214.
Yes.
Yes.
When we contended, my lord, similarly as
no impediment. Government. Yes, sir. Who appears for KD? Yes. Yes, sir.
In view of the submission made by paragraph 5, my lord.
Yes, sir.
Paragraph 5, my lord. At 216, my lord.
Submission consider and decide the representation submitted the petitioners in accordance with law by speaking order. Yes.
My lord, the learned land acquisition officer feels, my lord, the impugned order is impliedly, my lord, the final notification dated, my lord, 29/12 is quashed, according to me, my lord.
Yes.
Because it is not specifically mentioned, my lord, in the order, he says, my lord, consider, I have considered, rejected. My lord, this is how, my lord, the land acquisition has understood, my lord, and it was a futile exercise as far as my appearance before the land acquisition officer. and my lord, directing him, my lord, to consider our application.
Yes. Yes, sir.
Therefore, my lord, it requires to quash this government, my lord, the order at Annexure G,
Yes.
with a further direction, my lord, to reconsider it. After, my lord, I also request, my lord, to kindly quash this order specifically, my lord, at Annexure G, my lord, at
Reconsider it in accordance with
in accordance with law.
Yes, in
And take
accordance
into
with,
consideration, my lord, Annexure K, my lord, the government circular, my lord, specifically.
Just. Yes, just let you come. Yes, sir.
My lord, let the impugned, my lord, final notification be quashed. And also, my lord, the order at Annexure G, my lord, for consideration of our object, let it be, my lord, also quashed. Remand the matter for first consideration, my lord, and take into consideration Annexure K, my lord, the circular issued by the government which says, my lord, if it is a converted
Yes.
land, my lord, it can be deducted. And similar to the order passed by the land acquisition officer, my lord, in respect of graveyard, my lord, let also, my lord, they may be given an alternate, let an alternate land be given to Wipro, my lord, so as to see that, my lord, these poor laborers, my lord, will have their shelter, my lord. They have purchased this, my lord, with a hard-earned money, my lord. Let them have shelter, my lord. No prejudice will be caused, my lord, if an alternate land as similar to that of a graveyard is given to, my lord, Wipro. We are not coming in the way of Wipro setting up, my lord, a plant there or, my lord, an industry. But at the same time, my lord, it can be achieved by providing them an alternate land, my lord, elsewhere. This is my sum and substance of the argument.
Yes, so what he is saying that this gist of argument remand its matter in the light of consideration of your circular. What is circular that is referring to is one
K, my lord, K.
connection. Just a minute. Where is that circular? 185.
K, my lord.
Yes,
187 minutes.
332. Yes. According to you, your submission is you are not following the circle. That's why. Whatever may be saying, no. Certain aspects have been considered in this circle. Whether you follow or not, you follow. 186. Yes. Yes, various statements. Yes.
Operator portion and again.
Tell me. Where are you? Oh, yes. Yes, correct.
Then after
yes.
ಈ ಮಧ್ಯ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ವಿಚಾರಣೆ ನಡೆಸಲಾಗಿದೆ. ಅದರಂತೆ ಒತ್ತಾಯಿತ ಅರ್ಜಿದಾರರು ಕಾರ್ಖಾನೆಯ ನೇಕಾರರಾಗಿದ್ದರಿಂದ ದೀರ್ಘ ವಿಚಾರಣೆ ನಡೆಸಿ ಅದರಿಂದ ಅಂಶಗಳನ್ನು ಸತ್ಯಾಂಶಗಳಿಂದ
Sir, whatever they have stated is correct according to you. Well,
Yes, they are correct. Then the fact that it's
अंतिम है
I cut in over the day into the new government.
आयत तत्व means
It is the condition of the landlords. I am an act.
but it was in 2005.
Then my again,
Then allow the employees also to be stay there. They are so much worried about him.
he's even concerned. The second
Yes. Where it is stated that the circular is,
that is what they are saying.
which is that?
Yeah.
Which ayatatu? I know there are many circulars. There are many circulars. Which circular that you are following? You must have 100 circulars. Take for an example. Circular number 99 that I have followed. Or circular dated so and so.
So that's later on. Not necessarily.
That may be according to your.
Submission before this quarter. Submission. Continuity of the land asset.
Follow one more order better. You reconsider it. Write it detailed because from yes, that will be done. That will be your payment and that will be done, but you hear them pass out of pass out. Whatever may be written, they will follow the circular which is prevailing insofar as the since it's a preliminary notice 2005 and 6, the earlier circular. Whatever the grievances you put forth, whatever the grievance, irrespective of this circular. Surely.
With your lordships kindly, I appeal
Yes,
to
sir.
counsel for respondent number 4.
Yes, sir.
Wipro
Counsel-
Limited is the respondent.
Number 4, sir.
Yes, my lord. Wipro, my lord, is the respondent.
Yes, yes.
My lord,
You are only a beneficiary.
absolutely, my lord. I only seek to
You,
assist.
you have to follow the
My lord,
respondent authority.
I only seek to assist this course on the certain factual matters, as my learned senior counsel, Mr. Chandrasekhar has mentioned certain facts.
No,
I
you
just
will be also heard.
My lord, before that, I would only draw your lordship's kind attention to the judgment of this court, which is the basis of what is the proceeding now. If my lords for a moment takes back to the judgment which my learned friend referred to and see what the prayer was and what was the pleading and what was the order. The submission that is being made that it was impliedly repealing and setting aside the acquisition proceedings with great respect may not be correct. For a moment, my lords may kindly go back to the judgment of this court at page 197, which begins at page 197.
No, this have some substance of the learned senior counsel appealing for the petitioner was to give an opportunity to the petitioners to rehear them and pass orders.
My lord, this opportunity is what was sought in the earlier petition. And in fact, the situation today is the making of the with the making of the petitioner himself. Kindly for a moment, bear with me, my lords. Kindly bear with me for a moment. Kindly see, my lord, the prayer which was in the petition that was made at page number 214. The order which has been referred to, the judgment relied upon.
Yes.
At page 214, the relief that was sought in those petitions has been stated. Below, my lord, it says these writ petitions are filed. My lord gets that?
Yes.
Under Article 226 of the Constitution, paying to issue a writ in the nature of certiorari, quashing, setting aside the order bearing numbers dated 21/2/2017 at annexure F and direct respondent to consider the objections filed by the petitioners. At that point of time, my lord, the only relief sought was the objections which are already considered We're
No
sort of-
objection, that the objection that has been filed pursuant to the insofar as preliminary notification.
Absolutely, my lord. Then, while this writ
Because
petition
the reason
was
is
pending-
in this petition, what has happened? The preliminary notification was issued in 2005.
Absolutely, my lord.
That they have to consider. Tagoli.
My lord, while this writ petition was pending, the final notification came to be issued in 2018. This writ petition
Yes, sir.
was filed.
It will be considered, sir. It will be
Kindly
considered.
appreciate the date of filing of this writ petition.
Yes, sir.
It was filed before the notification, final notification was issued. No prayer was made in this petition to seek to amend or challenge the final notification.
Yes, sir.
On the contrary, the counsel for the petitioner only makes a submission to this court at para 3, my lord. At para 2, the petitioner himself says, I may only be given an opportunity for reconsideration of the representation without
Yes.
bringing it to the notice of this court that a final notification has already been passed and not choosing to challenge the same. With great
Yes.
respect, my lord, I must submit, having taken and knowing of the fact of a final notification, not choosing to bring it to the notice of this honorable court, not seeking to amend the writ petition, and requiring this court only to pass an order to reconsider the representation, with great respect, not coming before this court in clean hands. It is misleading this court. This court was
Yes,
not made aware of these facts while passing this
Yes,
order.
yes.
And the order that has been passed by this court is only to act in accordance with law.
Yes.
The law on the position.
Now they will act, sir. Now the KDB will act. In
My lord,
accordance
great
with that,
respect.
now they will act.
It is from 2005 till 2022. Repeated petitions have been filed to frustrate the acquisition proceedings. The industry has not been able to be set up in over these 17 years, and costs have been going up. And these petitioners have not filed number of petitions. This is only one of the orders of the last of the orders in this litigation, and one
Yes.
more orders are, and this continued.
Will be considered, sir.
be expressed.
Tagoli. Yes, sir. You want to say? When was the preliminary notification was passed? Then yes, you reconsider it. You reconsider it. In these writ petitions, the petitioners have challenged the acquisition proceedings dated 22/8/2019, within bracket annexure Q, pursuant to the order passed by this court in WP number 44903. 44903-97 of 2018, dated 8 July 2019, and also sought for quashing of the consequential orders with regard to the acquisition proceedings initiated by the respondent KG. Respondent state. They will acquire an respondent state. The relevant facts for the adjudication of these writ petitions are that the petitioners claims to be the employees of Messrs. JK Tires and Industries Limited, within bracket, within Vikrant unit, situated at Mysore, and are the owners of the residential sites situated in a layout formed in survey number 49, measuring 3 acres, 38 guntas, and survey number 88/1, measuring 34 guntas, situated at Mugarahalli village, Srirangapatna Taluk, Mandya district. It is further stated that the respondent KAGB has initiated acquisition proceedings in the year 2005, including the land belonging to the petitioners herein, and as such, passed the preliminary notification on 7/12/2005. Preliminary notification. It is that annexure. Annexure B and preliminary notification under section. Yes, sir. 28 class 1 of KADA Act 1966. Herein after referred to as Act. Within bracket annexure B. Thereafter, the respondent KDB has issued the final notification under section 28 class 4 on
31st December,
31
August
2006.
2006.
Reduced at annexure
C.
C. Full stop. The final notification dated 31/8/2006 issued by the respondent KGB was passed by this court by order dated 8th January 2016 in WP number 14733 of 2008 and connected matters as per annexure D. Immediately thereafter, the petitioners herein have filed objection to the preliminary notification dated 7/12/2005 as per annexure E. The said objections were considered by the respondent KDB as per annexure F dated 21/2/2017 and proposed to issue the final notification as per annexure 28 class 4 of the Act. As per annexure F. Immediately thereafter, the respondent KDB has issued the final notification under section 28 class 4, 28 class 3, 28 class 3, 28 class 4, 28 class 4. No, annexure G.
29/12/2018.
Under section 28 class 4. 20 under on 29/12/2018 under section 28 class 4 of the Act and proposed to acquire the scheduled properties belonging to the petitioner for the benefit of the respondent number 4 hearing. Immediately thereafter, the petitioners have in the meanwhile, the petitioners have approached this court in WP number 44903-997 of 2018 and this court by order dated 8th July 2019 as per annexure N dispose of the petition with a direction to the respondent board to consider the grievance of the petitioners in accordance with law. Pursuant to the same, the petitioners hearing have approached the respondent board as per annexure P, as per annexure P, and the petitions were heard in the matter by the respondent authorities and as per impugned order dated 22/8/2019, annexure Q, rejected the representations/applications made by the petitioners hearing. Feeling agreed by the same, feeling agreed by the order dated 22/8/2019, produced at annexure Q, petitioners have approached, have presented these writ petitions. I heard Sri S.M. Chandrasekhar, Lana Senior Counsel appearing for Sri H.P. Chandrasekhar, Lana Counsel appearing for the petitioner. Sri B.B. Patil, Lana Counsel appearing for the respondent KIA DB. Lana government, Lana so and so, Lana the appearing for the respondent state, and Sri Rajesh Chandra Kumar, Lana Senior Counsel appearing for Yuvina Rajesh Rohar, appearing for the respondent number 4. Sri S.M. Chandrasekhar, Lana Counsel appearing for the petitioner, contended that, the petition contended that the petitioners herein have converted the agricultural land into residential purpose way back in 1991, and the preliminary notification was issued on 7/12/2005, followed by the final notification dated 31/8/2006, which came to be quashed by this court in WP number 14733 of 2008 as per Annexure D, and thereafter, the respondent authority has passed an order under section 28 class 4 on 29/12/2018 as per Annexure G, without considering the objections raised by the petitioners herein, and thereafter the writ petition number 44903-97 of 2018 was filed before this court, and this court, as per the order dated 8th July 2019, within bracket Annexure N, disposed of with a direction to the respondent board to consider the grievance of the petitioner. However, the respondent board, by impugned order dated 22/8/2019, by cryptic order, disallowed the representation made by the petitioners herein without considering the circular, which is that circular, without considering the circular dated 3/3
Annexure K, my lord. 3/3/2007.
produced at Annexure K, and therefore he contended that, the grievance of the petitioner has not been properly met by the respondent board while issuing the notification dated 22/8/2019. Accordingly, he submitted that the impugned order produced at Annexure Q requires to be set aside in this writ petition. Per contra, contention. Per contra, per contra, Sri B.B. Patil and a counsel appearing for the petitioner, respondent KDB, vehemently opposed the petition by contending that the respondent board has scrupulously considered the representations/applications made by the petitioners herein in the impugned order dated 22/8/2019, and therefore he contended that the impugned order is just and proper, which does not call for interference in this writ petition. He also contended that, pursuant to the circular issued on 3/3/2007, subsequent circulars have been issued by the respondent government, and therefore, the consideration made by the respondent board is in accordance with the relevant circulars issued by the respondent government, and therefore contended that the petition requires to be dismissed in limine. Full stop. Full stop. Sri Rajesh Chandra Kumar Sonolana, senior counsel appearing for the beneficiary of the land, beneficiary/respondent number 4, contended that, the petitioners are time and again approaching this court and thwarting the complaints of the acquisition made by the respondent board, and therefore he contended that the writ petition be dismissed at a threshold and threshold, and accordingly sought for dismissal of the petition.
My lord, may I emphasize here, my lord, my submission is this, that the writ petition filed by them did not challenge the acquisition proceedings. And
He also contended that the petitioner's hearing have not challenged the impugned acquisition proceedings issued by the respondent board, despite challenging the annexure Q, and therefore the writ petition annexure Q, and therefore the writ petition itself is not maintainable.
I'm sorry, my lord, that my great
in the light of
submission. I'm sorry, my lord, that's
submission
not
made by the Learned Council appeal for the party.
My lord, for a moment, if I may kindly clarify for a moment, may make my submission properly, my lord. What I submitted, my lord, is this, that the judgment which has been rendered by this court on 8th of July 2019 in WP 44903, that petition, my lord, was filed even before the final notification under 28(4) was issued. The final notification, therefore, was not challenged in the said writ petition, though it
That's
was
what notifications of not.
While the notification was existing,
Further contended that as on the date of the disposal of the WP number 44903-97 of 2018, the final notification was issued by the respondent KADB, and therefore he contended that the writ petition itself is not maintainable without there being challenging the final notification issued by the respondent board. Next, in the light of the submission made by the Learned Council appealing for the parties, on careful consideration of the writ papers would indicate that the petitioner's hearing or the owner in possession of the residential sites formed in survey number 49 measuring 3 acre 38 guntas and in survey number 88/1 measuring 34 guntas situated at Mogarahalli village, Shiringapatana Taluk, Mandya district, and the respondent board has issued the preliminary notification on 7/12/2005 as per annexure B, followed by the final notification on 31/8/2006 within bracket annexure B. It is also not disputed that this court in WP number 14733 of 2008 and connected matters, passed the final notification dated 31/8/2006 issued by the respondent KADB, as per annexure D, and thereafter, the petitioners herein have approached the respondent board for consideration of their grievance in terms of the order dated 8 January 2016 produced at annexure D. In the light of the submission made by the senior counsel appealing for the petitioner, inviting the attention of the court to the circular dated 3/3/2007 in bracket annexure K, whereby the respondent number 1 government has issued the circular dated 3/3/2007, directing the respondent KADB to follow certain procedures while acquiring the property belonging to the landowners. In the guise of those circulars issued by the respondent government, the petitioners hearing have also challenged the notification. I have not also challenged the notification dated 21/2/2017 before this court in WP number 44903-997 of 2018 dated 8 July 2019, whereby this court, directed the respondent KADB to consider the grievance of the petitioner in accordance with law. In the light of these in the backdrop of these factual aspects, the respondent board, after considering the grievance of the petitioners by impugned order dated 22/8/2019, in bracket annexure Q, rejected the representations / applications / objections raised by the petitioners hearing. List of the operative, the consideration of the petitioners, consideration of the case of the petitioners by the respondent board reads as under page 256. Type. Type page number 256. Page number 256. ಅಲ್ಲಿ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿರುವ ಜಮೀನು enter including the operative portion. I have carefully examined the reasons assigned by the respondent board in the impugned order, wherein it is stated, wherein the impugned order has been passed by the respondent board, stating that the case of the petitioners has been considered. However, same cannot be accepted as the same is not within the circulars issued by the respondent board. Full stop. On careful consideration of the same, I am of the view that the respondent board, has not considered the case of the petitioners in the light of the circulars mentioned at 3.3. Annexure? 180. Annexure K, whereby the class 4 to the said circular reads as under. Page 186, class 4. Though the grievance of the petitioner herein that the land in question has been converted way back in 1991 and layout has been formed and residential houses, residential premises have been constructed before the issuance of the preliminary notification dated 7/12/2005, and thereafter the final notification came to be issued on 31/8/2006, which came to be passed by this court on 8/1/2016 as per annexure
D.
As per annexure D, I am of the view that the respondent board has not properly considered the grievance of the petitioner in the light of the circular issued therein, and in that way of the matter, the impugned circular issued by the respondent board dated 22/8/2019 produced at annexure Q is quashed. However, it is open for the however, liberty is reserved to the respondent board to reconsider the issue afresh and pass appropriate orders in accordance with law, taking into consideration the observation made above.
Lord, the impugned final notification will have to be quashed, my lord. Otherwise, the same repetition will be there. Lord, that is dated 29/12/2018, my lord.
Yes.
One other, my lord.
Yes, in your authority. Yes, that will be
But
considered.
instead
That
of
will-
board, my lords will have to say, my lord, special land acquisition officer. My lord. It is not the board, my lord. Your lordship will kindly see the 156, my lord. It is a special land acquisition officer.
SLAO is which respondent, sir? SLAO is third respondent. Madam, KDB ಇದೆಯಲ್ಲ ಅಲ್ಲೆಲ್ಲ third respondent.
ಎಲ್ಲ ಕಡೆನೂ ಹಾಗೆ ಬರ್ಬೇಕು.
Third respondent.
Board ಅಂತ ಬಂದಿದೆ.
Wherever the board is the third respondent.
Yes.
SLAO. Yes.
My lords
You
have cost.
reconsider it, sir.
Annexure G is cost, my lord.
Yes. So you reconsider it. You reconsider it and pass appropriate orders. Yes. Yes, it will be considered. Take into consideration the circular issued by the government. That's all. Yes. Which one? Then it will go because earlier it was gone up. Because earlier. Well, ತಗೊಳ್ಳಿ madam. I will further clarify. Now I will further clarify. This court, it's also made clear that as this court by order dated 8 January 2016 in WP number 14733 of 2008 as per annexure D passed final notification dated 31/8/2006 and directed the respondent third respondent hearing to reconsider the issue and in the light of the same, any subsequent notification issued by the respondent board requires to be passed until the grievance of the petitioners has to be met in accordance with the representation, in accordance with the circulars and the representation made by the petitioner would be considered. Yes. It is considered, you consider it. You reconsider it. Yes, it will be considered. Next matter.
Grateful, Maharaj.
Annexure A. Latches Chandra. Yes.
52.
Milord,
Majority PM.
yes, Milord, I request for time for filing of statement of objection, Milord.
On a counsel appearing for the respondent seeks short accommodation to file statement of objection. List after 3 weeks.
Oblige, Milord.
Yes. Yes. Objection is filed as. What is challenge, sir? To quash the impugned final demand notice. Annexure? Yes. Next, sir? Yes, sir. Yes. What is this actually? The lease come sale, huh? Lease come sale. Shopping complex. Yes, sir. Yes.
Next, the license.
You are deposited. Then yes. Yes. Where are you reading? Class? Class 11. Ah, yes. License avadi 5 ವರ್ಷ. Yes. So mutually you can. Yes.
Class 15. License transaction our
Yes.
conditions. And
20?
24.
30.
5 ವರ್ಷಗಳ ಅವಧಿಯಲ್ಲಿ 31. ಅವಧಿಯಲ್ಲಿ ಯಾವುದೇ ಸಮಯದಲ್ಲಿ ರಸೀದಿ ಮಾರಾಟ schedule. I expect to suggestion 5 years ago.
Yes.
First, that we have not stated because the violence has been expired here. First, that we are paying. Then the person before the lordship, this license has. Then that I have keep on paying the amount. Initially,
Yes.
That BDA has issued saying that
Yes. Next. Yes.
96,020. That is which we have paid to them. Then NDC. This notice actually has been issued. This notice around 46,454. But they said that they have demanded.
Yes.
Or that it is not there. But in the year of 2019, they have demanded.
Yes. Yes.
This notice has been carried by
So consider your case. Consider your reply.
yes.
Next.
Then that they have not provided opportunity. I have given details about the statement of actually. Where is the statement of 2010, we have paid.
Yes.
And calculation which we have given.
Yes.
And we have paid that. Actually.
Yes.
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 This notice that they have demanded an amount to 25 lakh 5,000.
Yes. Correct.
By him of the money.
Yes.
Another notice has been issued. Let's just see.
Yes.
Here, that they have stated 46,454.
So you have been show cause notice first. Yes.
Then I have replied saying that I have paid without the 24 medicines. And we have paid accessible as against we have paid. Total as on we have. Then this notice as against those notices. They have issued an JB stating that, my lord, when we see book 6,
Yes.
Parvangi Shilpavati is 9 lakhs.
Yes.
99,000. ಹಾಗೂ ಬಡ್ಡಿ ರೂಪೀಸ್ 99 ಲಕ್ಷದ 90,000 ಒಟ್ಟು 1,59,000.
Now the arithmetic has to be done.
Yes.
That's all.
They have not.
Only arithmetic that we have to do.
46.
Objection is.
46. Yeah.
And
then afterwards, we have that 25 lakhs cash they have said.
Yes.
So, my lord, they said 1,59 lakhs. 1,59 lakhs.
Yes.
And interest of my lord 80 lakhs interest on the amount paid.
Yes.
Then my lord, this my lord, when you see the statement of objections that they have filed.
Yes.
Before this honorable court and all the facts.
There is no interim order. It will be taken up any other.
Interim order is there. Now, 15 lakhs are paid.
Yes. As on today, there's no. Then it will be taken. It will be taken up later. There's no urgency.
Now, 2 crores lakhs are still at hand.
Not that much disposition available. Issue rule, madam. Yes, got him. List after 3 weeks. List after 3 weeks. Some appeal is also pending. Right appeal. List after 3 weeks. Next matter. Huh? Let us read. Arithmetic. Not. No, not after 3 weeks. Let us.
Lord, serial
Mandish
number
Patil.
54, my lord, I appear for the petitioner.
I
request for a week's accommodation, my lord.
The request made by the Lana Council appearing for the petitioner. List after 3 weeks.
Lord, in the meantime, my lord, kindly direct them to file statement of objection, my lord. Because statement has not been filed.
Just a minute. What is this matter? Anyway, he is seeking time. Let us.
Friday.
Next, M is challenge. One minute. I think similar petitions. No, similar petitions is referred to. I think we have. I think, madam. 26th. List on 26th. List on. I think similar petitions are coming. List on 26th. Let us proceed.
Oblige, please.
List on 26th. Yes. Vachan. Statement is filed, madam. No representation has been made by the respondent. Council appearing for the respondent. Hence, issue notice to the BDA. See, he has to come. Last week also he did not come. Every time he cannot be like that. So no. Issue notice to the SLAO to appear before the court by next date. Let us please. So 1 or 2 occasion I can give. Oh, there are not on every day. Yes. Sorry. Or else, see, just put my predecessor. Though the commissioner, BDA, and respondents have served, none entered appearance once. Let us do this. No representation on behalf of the respondent. The respondent but two shall appear before this court by next Monday court. Without fail, yes. Without fail, yes. Let us we will see. Previous two orders are there like this. Next matter. 56. Yes, sir. Who is appealing? Yes. What is the prayers? Just what is the prayer actually? TDR. ಯಾವತ್ತು ಒಂದು 2:30 ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿವಿ ಯಾವತ್ತು 2:30 6th 5th 6th what will happen, civil matters will be there, RSA matters 7 at 2:30. Just a minute. Let us retake it. So accommodate both the parties. 5th at list on 5th at 2:30. Yes. Yes. If you award bearing, first the award. The compensation. Yes, sir. Objection file ಮಾಡಬೇಕಾ? ಅದಲ್ಲ, maybe taken up now. Ready ಇದೀರಾ? Ready sir? Yes. Yes sir. So award is by this is a notification. ತಿಳುವಳಿಕೆ ಪತ್ರ. Yes. No, this is a notice section. Annexure A is the notice. Where is that? ಜಮೀನುಗಳ ಎಕರೆ ಒಂದಕ್ಕೆ 18 lakhs. Yes. $29. Yes, sir. Yes. Yes, sir.
No, consent order.
Consent award. Consent award. When was the consent award passed? 27? Then how the writ petition is maintainable? They paid that you received also. But it is a consent award. Whether it's 18 lakhs, 5 lakhs or 1 crore. You have entered into an agreement with them. You have entered into an agreement. Anyway, you have consented for the award. Then a consent agreement is entered into. Where is that? Yes, sir. Just a minute. Where is the consent awards? R1 I have. That is a letter dated 7/6/22. Where is the consent letter? Yes. 29 class 2 nalli, where is the order is passed? '29 class 2 nalli, you have to pass a consent award. Where is that award? You take your instructions better. So, at the request made by the Lana Council appealing for the respondent board, just after 3 weeks. Yeah, let me get. Respondent number 2 is directed to secure the original records from the respondent board. ಮೇಲ್ಗಡೆ ನನ್ನ council appealing for the petition submitted. Bangalore ಅಂತ ಇದೆ. But address change ಆಗುತ್ತೆ. Entire address has to be changed. You implead them then. You implead petition. You implead them. Entire address will be changed. Then get the records from the respondent board. Next. Is Shivaram? Yes, sir. ಹಾಕ್ಬೇಕಾ ಫೈಲ್ ಮಾಡ್ಬೇಕಾ? Two weeks. Let us fix. At the request made by the Lana Council appealing for the respondent to file the statement of objection, list after respondent number 2, list after 2 weeks. List after 2 weeks. Yes. Yes, anyway, you filed it. Yes, you're ready. Anyway, seeking time. Seeking time, let us finally, who is the answering party? The respondent number 10. Then a council appealing for the respondent number 10 seeks short accommodation to file the statement of objections. List after 2 weeks. Let us fix. Let us, we cannot. Let us fix. No, date could just ಬರ್ತಾ ಇದೆ. Yes, sir. Yes, sir. Who is the answering? Yes, madam. Yes, madam.
Yes. My lord, in this matter, serial number 62, right? 62. Milord, award has already been passed. Milord, second prayer, the issue of writ of mandamus directing the respondent to award. Award has already been passed.
Objection you have filed, madam?
No, we have not filed yet, Milord.
Let you file. Let you.
Milord, compensation has already been awarded. Milord, we are ready to pay compensation. They have to just produce documents.
You file. You put it everything in writing.
Please, Your Lordship.
And a counsel applying for the respondent 2 weeks time to file objection to the petition. Just after 2 weeks. No, no. The request made by the Lana counsel applying for the respondent number 2. List after 22, list after 2 weeks, list after 3 weeks. No. Let us we will see. List after 3 weeks. No, now they will get proposal. Good for you. Maybe good for you. Next. Okay, other matters. So other matters up to 82 will be taken up next week. Huh? Up to 82 will be 7. On 7th it will be. Wherever the interim order is there, it will be extended. Wherever the interim order is extended. Which one? 72. No, Nadru.
Serial number 69, madam. Just for mandamus.
Yes, sir. 48 ಅಲ್ಲ 48 ಅಲ್ಲಿ interim order granted earlier no date
My lord, serial number 69, my lord. Serial number 69, just for mandamus, my lord.
serial number madam all based on Monday.
Achha. ಅಯ್ಯೋ 64 ತನಕ ಬಂದ್ರು ಸರ್ 69 ನಮ್ದು ಆಯ್ತಲ್ಲ 1.5 ಆಯ್ತು ಪ್ಲಸ್
Madam, which date given for all those cases? Madam?
What officer?
Yes, madam.
Yeah, which date given for these cases? Till 82? Till 82, which not taken up. Which date given?
7th of September, madam.
Thank you.
Madam, 69, madam.
Same thing, 7th.
7th of.
All B group matters urgent to 7th.
Revision petition is allowed. Order dated 22/7/2013 is set aside and the matter is remanded to the family court for fresh consideration.
Number 84, PM signal account.
Please, my lord.
Appeal is allowed. Judgment and decree passed by both the courts are set.
Grateful.
Taking notice. Ready to be first.
So, madam. Serial number 21. Withdraw.
Complied with. And a counsel appearing for the senior counsel appearing for the petitioner on behalf of Mr. So-and-so submitted that the office objections have been complied with. Registry is directed to verify the same. Yes, sir. Yes. 45.
Having regard to note section 57.
So you have abandoned.
2 minutes not.
Sorry. Cannot AG accept notice for respondent number 1. Yes, Sachin. Yes, Sachin, accept notice for respondent number 2 VDA. Respondents are restrained from disposes the petitioner from the scheduled format. Till next step. When a counsel appearing for the petition, sir, copies. Yes. In the event if the petition is not dispersed yet. Yes. Next again. Okay. 230 matters.
Serial number 87, Nanda Reddy PM.
May I appear for the petitioner?
Yes. Yes, Vivekanand.
In all these petitions,
yes,
only the preliminary notification has been issued. No final notification so far issued for the last more than 10 years.
10 years.
Last time, of course, the previous wanted to allow the petition on the ground. Even till today, they are not come up with that.
This is like a real estate agents.
But the
The urban
petitions are
development.
now nowhere considered. So that is open, it is open for you. In 2007 it is possible, not in 2020. Prices have gone up a lot.
2011 now is the notification, the preliminary notification. For the last more than 11 years, nothing has been happened.
Yes. 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 That's a different thing, but since the final notification is not goes. Yaudri, putting 18,000. Next, 87.1. 87.1. ಯಾವುದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅದೇ ಗಂಗಾಧರ ನಾಗಮೋಹನ್ ದಾಸ್ 2014 ಅಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲರೂ ರಿಪೋರ್ಟೆಡ್ ಆಗಿ KLJ ಆಗಿದೆ ತೊಳಿ ಮೇಡಮ್ ಎಲ್ಲರೂ KLJ ILR ಕರ್ನಾಟಕ CG ಗಂಗಾಧರೆ ಅಂತಲ್ಲ CG ಗಂಗಾಧರೆ $92 it cannot be possible. $92 appears for serial number 92. Serial number 92. It may be taken up some other day. Not possible. 92 nalli just after 2 weeks. 92 just after 2 weeks. Yes, madam. Yeah, serial number 92 will be taken up after 2 weeks.
Yes.
In these writ petitions are directed. Monday order ಬೇಕು ಇಲ್ಲ common order. In these writ petitions. These writ petitions, the petitions have challenged. Preliminary notification is common.
Notification.
Challenge the preliminary notification. dated 7/7/2011, issued by the respondent number 1 for the benefit of
Second respondent.
second respondent issue, the government alla.
Government file notification, no? Urban Development Authority.
Finally by the government, issued
Yes.
by the second respondent for the benefit of allotment of sites in Tumkur city. The relevant facts for the adjudication of these writ petitions are that the petitioners, please sit down. The petitioners are claims to be the petitioners claim to be the owner in possession of the scheduled property.
Schedule prayer B like
There is a
prayer B in all the writ petitions that can be extracted.
The owner in possession of the various land stated in paragraph 1 of the writ petition.
Yes.
And
prayer B.
And the contention in the writ petition that though the preliminary notification has been issued by the respondent authorities on 12/7/2011 for the purpose of formation of residential layout, the respondents have not taken any further action in the matter. Accordingly, the grievance of the petitioner that the respondent authorities have abandoned the scheme for providing scheme notified in the preliminary notification dated 12/7/2011. Hence, these writ petitions are presented. Her Sri Nanja Reddy PN for the petitioner, Sri Shauri for the respondent number 1, and Sri TP Vivekananda for the respondent number 2. Sri Nanja Reddy, Lana counsel appearing for the petitioner, contended that though the respondent authority has issued the notification under section 17(1) of the Kuda Act, Karnataka Urban Development Act 1987, however, no further action has been taken pursuant to the same. Accordingly, the preliminary notification does not survive for consideration, and as has sought for quashing of the notification issued under section 17(1) of the Act, herein after. Per contra, Sri TP Vivekananda Lana, good evening. TP Vivekananda Lana counsel appearing TP Vivekananda Lana counsel appearing for the respondent authority, sought to justify the notification issued under section 17(1) of the Act, and he further contended that the relevant communications have been made between the government and the second respondent inter alia with the Director of Town and Country Planning for the purpose of housing layout in the Tumkur city, and as such, he contended that the writ petition deserves to be dismissed. Sri Shauri Leonard AGA, appearing for the respondent, reiterated the submission made by Sri TP Vivekananda, counsel appearing for the respondent number 2. In the light of the submission made by the Lana counsel appearing for the parties, It is not in dispute that the respondent number 2 has issued notification dated preliminary notification dated 17/7/2011 under section 17 clause 1 of the act, whereby the respondent authorities notified the lands in question for the purpose of proposed formation of a residential layout. There, full stop. On careful consideration of the red papers as well as the statement of objections filed by the respondent number 2, even though the preliminary notification has been issued in the year 2011, the respondent authorities have not issued respondents herein have not taken steps to issue the final notification, and as such, into consideration the law declared by this court in the case of CG Gangadhar versus Mysore Urban Development Authority, Mysore and another, reported in 2013 4 KLG 559, wherein this court at paragraph 4 to 6 observed as follows. KLJ applying the principle laid down by this court in the aforementioned petitions, no doubt the respondent number 2 has issued the preliminary notification in the year 2011. However, the authorities have not explained the inordinate delay in executing the scheme, and that apart, no final notification is issued as required under section 19 of the act. 19 class 1 of the act. In the circumstances, that we have to matter, to view that even after lapse of 10 years, no action has been taken pursuant to the issuance of the preliminary notification on 7/7/2011 under section 17(1) of the act, and therefore, the petitions are allowed. The impugned preliminary notification dated 7/7/2011 is quashed with regard to the lands belonging to the petitioners. That's it.
God bless.
Petitions are disposed. Yes, sir. I know. I taken into consideration statement. Part ತಗೊಂಡಿದ್ದೀವಿ. Your submission ಹೇಳಿದೀವಲ್ಲ, KP Vivekanand. One minute. I think I've taken your objections. Just one. KP Vivekanand statement of objections. Or objections? Or ಮೇಲ್ಗಡೆ experience this petitions is Anjareddy. The respondent authority impugned preliminary notification has been issued by the respondent number 2. And as such, the statement of objections has been filed, and the respondent authority has taken defense that the consideration with regard to the final notification is in the realm, in the domain of the state government. As such, sought for dismissal of the petitions.
So please.
Yes. 40. 85.
Second for 85, the NR9 for declaring order.
I make to appear for appeal.
Yes. Appeal dismissed.
Please.
Appeal dismissed. Yes. Perfect. Petition dismissed. Petition dismissed. 88.
Second number 88, regarding matters in the
National Highways case.
Urgency is there. If there is no urgency, I will take it up. Huh?
With regard to the second award, the reason the meter I can just take it
No,
off.
I mean, the event if taken up, large number of work is on my table. Instead of hearing that.
Because the question is, who is supposed to go before the arbitrator? But the first award has been passed by them.
Yes.
Then the order of the on the national highway, this is the acquisition of a national highway for the formation of road. Award has been passed by the competent authority appointed by the central government.
Yes.
So that award we were there.
That's assistant commission. Assistant commission is the competent.
The land acquisition officer is the competent authority. And that you have put in the annexure D, that according to him as the competent.
Yes.
Now he passes an award. But now what they do is, the national highway member, they go to him, they direct him that you have passed an award. You have the safety what you have taken into consideration is not right. Then not he again passes a different award. But there is no scope, and now they come up with a contention. No, that award was only a draft award. This is the proper term. There is no draft. What they say, if you want to challenge this award, you go to the arbitrator. But why should I go before the arbitrator when the first award itself is correct? And
you are the land users.
Land users. And even on that basis, in fact, what happened to the land acquisition officer? But they say this is with regard to some safety. Which you should
How long you take? I'm ready to take it up. Anything is both of you are there so that
I understand.
This is
it becomes a easy argument for you all also.
92 is.
I think both you will not take more than 15 minutes on each side.
Yes, sir. And the other petition. Yes, 15 minutes. I have some dictation.
Because last time of the it was passed over and we left over and 2:30 was specifically on.
Very good. I will take it up. 15 minutes anyway. I have. Because except your case, no other cases are there. Except your case, no other cases are there.
I was thinking because the other day also going to be regarding 100% of we are case forward.
In the event if taken up, it has to be completed.
My lord, serial number 65, my lord. The
So
board,
it is adjourned to 7th, sir.
grateful, man.
'92 is adjourned. Yes, sir. 92 is adjourned. Because number of matters are listed today. It may not be taken up today. That's get yes. Get records fermented with. Get the original records pertaining to this. Just after 2 weeks. Very well. We need not wait. Stop that. Yes, delivery. Very good. So finding startup. In the light of the submission made by the council appearing for the parties, I carefully considered the factual aspects whereby the respondent board has issued notification under section 28 clause 1 of the act to propose to acquire the land, including the land belonging to the petitioners on 25/5/1996, followed by issuing the final notification under section 28 clause 4 of the act on 30th September 1997. The grievance of the petitioner that the respondent board has not utilized the land belonging to the petitioner, and as such, the respondent board has abandoned the acquisition proceedings. It is also the case of the petition that the land the possession of the scheduled property still vests with the petitioner. However, on careful consideration of the bid papers would indicate that the careful consideration of the would indicate that the respondent board had taken the possession of the land and handed over to the respondent board on 13/7/99 under section 28(8) of the Act. It's also it's also written in furtherance of the same, the respondent board has entered into lease cum sale agreement with the industrial concern on 30th/11/1998 as per annexure R1. In this regard, in this regard, following this regard, in the background of these aspects, the petitioners have challenged the impugn notifications issued on 1996 and filed the writ petition in the year 2016. No proper explanation has been stated in the writ petition with regard to delay and latches in challenging the acquisition proceedings. In your the law declared by the apex court in the case of Banda Development Authority. In of the law declared by the apex court in the case of so and so, writ petition deserves to be dismissed on the ground of delay and latches. 2011 5 SCC 395. 2011 5 SCC 395. ILR 2009. ILR 2009. Karnataka 1789. ILR 2009 1789. It is also relevant to cite the judgment of the apex court in Ahuja Industries Supra, whereby the apex court has held that the acquisition notification issued by the authorities is based on the revenue records based on the revenue records, and therefore the argument advanced by the petitioner that no notice has been issued to the petitioner cannot be accepted. Banda Development Authority, it's also pertinent to mention that since the writ petition is filed 96, filed after 20 years from the date of issuance of the preliminary notification, for which no plausible explanation has been offered. It is well established principle in law that when there is an inordinate delay in filing the writ petition, challenging the acquisition proceedings, the court should not interfere with the acquisition proceedings. The interference under Article 226 of the Constitution is discretionary in nature, and with regard to dealing with land acquisition proceedings, in a writ petition which suffers from inordinate delay and latches, has to be exercised with great circumspection. See and see Jasveer Singh and others versus State of Uttar Pradesh, reported in 2017, 6 SCC 787. Though the Lana Council appearing for the petitioner, argued that the section 24 clause 2 of the new act, so and so, right to so and so, is applicable to the factual aspects on record. However, in view of the law declared by the Apex Court, in the case of Special Land Acquisition Officer KIADB Mysore and another versus Anasuya Bai (D) and the others, reported in 2017, 3 HCC 313, wherein the Apex Court has held that Section 24 Clause 2 of the 213 Act do not apply to the proceedings under the provisions of KIDA Act. It is also pertinent to mention here that the petitioner cannot revive the dead and stale claims by challenging the impugn notifications which is of the year 1996, and therefore, therefore, I'm of the view that the petition deserves to be dismissed on the ground of delay and latches. It's also relevant to cite the judgment of this court in the case of so and so reported in 2009, Karnataka 1789. Wherein this court has held that wherein this court after considering wherein this court after considering the provisions contained under the Act has held that the land can be acquired for establishing the industrial area and industrial estate under the Act, and incidentally, the main object of the industrial development, land can also be acquired for creating amenities and industrial infrastructural facilities. Taking into consideration that the land acquired by the ADB has been allotted to various allottees, including the allottee as per Annexure R1, I'm of the view that yes. And therefore, I am of the opinion that when the acquisition proceedings are completed and the acquired land is developed, the clock cannot be put back by quashing the proceedings, as the allottees are in set to position of the scheduled properties. And in that matter, I do not find any acceptable ground to interfere with the acquisition proceedings initiated by the respondent authorities. Accordingly, the petition is dismissed as devoid of purpose.
Number 88,
You can begin. Let us begin. You can begin. For the picture. So the common question in all these.
Yes, yes. One matter you got to decide, then the petition is by the land.
90.1. WP 8458. Yes. $84.50.
The requisition, the land user, where the land user has been properly acquired by the national highway.
For the purpose of?
For purpose of road widening. This is covered by the National Highways Act 19. The award that we have challenged is at annexure A, page 18, dated 22/1/21.
Yes.
But I'll come to that a little later, because according to us, this is the second award. It could not have been passed. Now, your lordship may kindly turn to
one judgment. Know something about it. Fact, add up here.
Says that you can't review.
Review.
Yes.
Now, in so far as NHA itself,
yes.
non something about had appeared, it was referred to. It was referred to, saying that there should not be any second award.
Yes. That's what even about the 18th April 2011. Justice B.S. says.
So this is the first award. First award was on 22/1.
No, the first award was on 31/20.
Page.
Annexure D, page 75.
75.
Do the document kindly see?
75.
Yes.
1 minute.
Now here, your document kindly see this, the date, and it is said as award.
Award under section 3G.
Under section 3G of Sony. But here, it is not written as any draft award. And then, the next page 76.
Yes.
The special agreement is not the signs it all.
Yes.
The amount recommended is 20 crores 34 lakhs 20,620 for the entire village.
Correct.
Now look here, and if the lordship sees annexure C.
Annexure C.
That is page 70.
Yes, sir.
If your lordship turns to page 73.
Yes.
The last two lines, this is 27 June 2014. Next is the powers conferred going to the section 3, the National Highways Act, authorizes the special land acquisition officer, National Highway Authority of India, as a competent authority to perform the work.
Yes.
Of such. So that also according to the Act as the 3. The competent authority.
3 is the.
Yes, so he is the competent authority.
Correct.
Now, so after this award is passed.
Yes.
The lordship turns to the next page after the award at page 75, 76.
Yes.
Lordship turns to page 77, annexure E.
Yes.
So the National Highway Authority of India,
Yes.
they write a letter to the project director. This is on 21/1/21.
Correct.
This is reference to your letter cited under so and so reference wherein submitted the 3G awards for land structure and so on. Then while examining the awards, the following discrepancies are noticed.
Where are we?
We got page 77.
77.
Annexure E.
Yes.
We got then sir.
While examining the awards,
Yes, sir, while examining the award.
the following
The
discrepancies.
following discrepancies are noticed. While calculating so, but I'm not going to that. The much training turn to page 78.
Yes.
In view of the above,
It is requested.
it is requested to reduce 3G award by SMAO as per the prevailing practice.
Where's the
Followed by
practice?
other CALA, CALA.
So which practice? Prevailing practice.
What? They should have done.
Only remedy available for them to challenge this award in appeal.
And before the arbitrator.
That's a deputy commissioner
The 3G.
on 3G. Correct.
You are also said aware. But the land acquisition officer has to be an impartial person. He cannot be, he cannot say that I will send the award for upload to the national highway. Then they will always, and in fact, the judgment which you have produced along with the petition, there they say, suppose if you have to revise the second award, why not third award? Why?
This finality.
So this is what has happened. If the budget sees in the rejoinder,
yes,
the option can be take the rejoinder with the document.
the very same. Very same petition.
Apart from the direct petition. The 8458.
8458. Yes.
8,000 citizens.
16,000. 8,458.
845.
Yes. Yes.
Yes.
Page.
Now, if the logic turns to page annexure Q,
Annexure Q.
the DC order, what happens in the logic? Page 15.
Jilladhikari.
Yes, Jilladhikari. In fact, if the logic turns to annexure P, page 13, the SLO in fact writes that, Lord, may I just make this submission?
Yes.
What has happened is, Lord, from 20 crores they come down to 16 crores. Their only grievance is that they are not the municipal limits. If it is outside the municipal limits, 12 and 12.5, for the purpose of stamp duty, it has to be considered as NA. And the stamp duty accordingly has to be paid. And if it is outside the municipal limits, within the municipal limits, it's 20 cents.
Yes.
So, it is only for the purpose of stamp duty. Now, what has happened is, they have taken the value of the land, the savings which are less than 12 cents. So that they say you could not have taken that. In fact, now you're watching, which is the, in fact, the land acquisition officer writes to the DC that we can't do this. So and then he writes to the DC that is at page 13, annexure P. The land acquisition officer to the DC.
He is an arbitrator. Deputy Commissioner is an arbitrator.
Yes, not in the
In fact, how can SLO is addressed? How can a SLO is addressed? Unless appearing in.
That is the reason, in fact, I was saying the same thing. So, now what the DC does is, now what the DC does is at page 50.
Yes.
I just read this. The special land acquisition officer competent authority by letter cited above has stated that pertaining to the acquisition of land for solution, they have set award of 10 million for approval to and their officers have been instructed. They say that the sale transaction of land below so and so are considered as alien land as per CBC guideline, and these type of transactions are not acceptable for the adoption of land rate in India, or hence they requested the instruction in this thing. They still have submitted the calculation
showing the guidance right, the rate per square meter with the highest half transactions are considered. And the rate when the transaction below 12.5 at 25 cents and 5 another exclude.
Yes.
When transactions below 12.5, 25 cents, 5 are considered, the rate per square meter is 2,131.
This is only with respect to quantification. Irrespective of the same. Whether we can, whether he can redo all, whether he can redo that at the instance of the respondent.
No, he cannot do it. No. He cannot do it at the instance of, because they, in fact, they go to the extent, in fact, but the DC also says, section 26, the right way compensation transparency so and so. The average sale price has to be determined taking into account savings or attendance to the register of similar type of area.
Yes.
This is the facility with the immediate clear of here. If the acquisition has proposed to be made, according to SLO being the competent authority is subject to outcome. Converted land rate in this in village is 5,000 per square meter. So and so. Further, mark what is the second paragraph. Comes under the town municipal limits and the developing villages. Majority of registered transactions in these villages are below 12.5. So they say here it's below that, so you have to consider it. So the land develops to determining the rate only on a few transactions will not indicate the actual prevailing market price and not in par with the guidelines on the act. The landowners will not accept such negative rate and will start filing arbitration applications, requesting to enhance the rate to return increase the burden. The core purpose of the right to pay for transparency land showing question property. When we are not assuming they are right, we are not doing the neighboring land that also are produced. But there they are taking about the state transactions below 12 cents. Even though the same CBC guidelines are applicable. But there they do it at page 98. But at 24/9/21 they pass an award. They may not take consider it. Here they are not considered. So not here, in fact, with regard to the direction, and then what I read out even I produced the same document again at page 18. There letter 21/121.
Yes.
There they say please review. Then page 17 of
yes.
the
18.
review of the awards requested to review CG award by SLO as per the prevailing practice. Procedurally follow. Lord, you have said what is the prevailing thing. Then you also kindly turn to annexure 390.
Yes.
22/121. Subject revised 3G award for land in Padumarnadu village.
Yes.
So again they are saying revised. And in fact, they say there is a direction. What he says as per that award, page 23 now.
23.
So this is the award.
Yes.
And in this, the logic turns to page 26.
Yes. 36.
The middle of the page, page 36.
1 minute. Yes.
Dry land. Look, the second paragraph.
Yes.
The regional officer Bangalore wide letter dated
21.
so as directed to adopt the CBC guidelines. So that is acting under the direction. And this is page 17. This is that letter 21/121 which I read out to you about. So if the SLO says that I will direct it. So how can that be done with the direction? And if the lordship because of the last time when the matter came up, but we had written that the SLO does not have the powers. Now the same advocate now appears for both the national highway and the land acquisition office. So he said that I don't need to fight. When we said then your lordship directed him to fight on behalf of this. Lord, now the objection filed with the SLO is saying about Balbak. Should the SLO not say that what was the consideration, what happened, why did I do this, why did I pass this award, what was the first? Nothing has been stated. So the whatever objections have been filed by national highway, the very same objections have been filed by the land acquisition office.
Except signature.
So except the signature, the affidavit only varies. That's what. And apart from this, but the Urbi one, even if anything is to be taken, and then they make this decision. Now, there one more contention. It is not maintainable because there is an alternate remedy of going before the arbitration. But now my question, I have asked myself this: when there is an award already there,
Yes.
So in the national, even now what they are saying, that those savings they could not have considered where the land was below 12 cents.
Yes.
So can they not go before the arbitrator and develop that challenge? Is the same thing to them like that. When there is already an award which is not being challenged, which is not a draft award, there is no provision for a draft award. It does not say it's a draft award. The judgment court, I will not, if your lordship sees annexure K.
Annexure case.
Yes, but that is the Bombay High Court judgment.
Page
86, it starts from 86.
86. Yes. Yes, sir. Aurangabad.
The relevant 96, in the first paragraph, the last few lines.
96.
Page 96. This is in a writ petition.
Yes, 90 para.
This is para 20.18 on page 96.
96. Yeah.
The first para, the last few lines in the first para.
Yes.
This would demonstrate that no power of review or for that matter power.
Where 96.
The award or so whatsoever.
Paragraph 2019.
Yes, above 29.
This would demonstrate
Yes, this
no
would
power of
demonstrate
review.
that no power of review or for that matter a power to take any correction in award parts for whatsoever reason has been conferred upon the competent authority. The status of the competent authority and the nature of the power exercised are maintained considering whether it would have an inherent power of review or solution. But this has been held that they don't have the power. And then with regard to the impartiality, then your lordship may kindly turn to 1031.
Yes. Yes, sir.
Fifth paragraph, the third paragraph from the bottom, that is 27. Your lordship, so above 27.
Yes.
And just 3 lines in that paragraph.
Yes.
WP number so and so, the absence of this, it cannot be held at the competent authority and the statutory act to have any power. Any reason whatsoever. That matter, additional award, or the same.
Correct. Yes.
So same thing will be them.
Yes.
But in the first paragraph, the last 2 lines,
yes,
the competent authority appointed is supposed to be an independent person. And has to dispassionately use and apply the powers vested in it for the purpose of implementing the provisions of the statute, which has to be done without fear or favor from any quarter. However, in the instant case, the competent authority, instead of doing so, clearly appears to have divested from its power and duty in order to favor the acquiring body, which clearly ought not to have been done, the correction of so and so. That same thing has been done. But now the judgment of our High Court at annexure LK 107.
Yes.
In fact, here it was enhanced, so that the court did not accept. Paragraph 13, in page 122, internal page 16 of the said judgment.
Para 13.
Para 13. The question is whether respondent number 1 has any such power under the provisions of the Act to pass such a second award. The answer has to be an emphatic no. There is no provision in the Act holding respondent number 1 to pass a second award. Once an award is passed, determining the competition. As for the provisions contained under subsection 5, section 3 of the Act, the aggrieved party who does not accept the amount has to make an application to the arbitrator appointed by the central government who will determine the correct amount paid. As per subsection 6 of section 3 of the Act, the provisions of Arbitration and Conciliation Act are made applicable to source. Then I'll take the losses. Para 14 in the next page.
Yes.
In the light of so and so provision made conferring power jurisdiction of respondent number 1 competent authority is part second award on the same subject matter. The impugned award passed enhancing the compensation by passing a second award has to be characterized as illegal and untenable. Then the Lord will also kindly turn to para 16.
Yes.
In the instant case, what is sought to be done is to pass another award in the place of the earlier award, by enhancing the compensation, adopting a different method by conducting spot inspection and by taking notice of other documents made available. If this is permitted, then the question could be asked as to why not a third or fifth award be passed by the competent authority at the instance of either of the parties. Such a situation, if permitted, will introduce total uncertainty and chaos. In the event that the competent cannot do such a with no such competent written act, then the impugned supplementary award cannot be sustained in law as referred to the acted without jurisdiction, without any authority. In fact, we had saying is a supplementary award, I will be to certain other document, but
Even that cannot be done.
This is under the same thing. I'm not your law. Say that what other judgment happened. Now I looked into that.
One chance.
I will look at and then give. So now, the question is this. Award has been passed. 20,000 award has been given to the entire village. Now, on their instructions, he comes and he redeems the 60. Now there is an award. But now, even if my losses are persuaded by us in the parliament, and the second award is released, what would happen about the first award would be? So we are at liberty to challenge. Go before the arbitrator and tell that you please consider this could not have been considered, that would not have been considered. But
Even it is open for this.
yes, that's all.
Ready or one more date? No, one opportunity we will give. Not over. Yes. Roger. Yes, first.
But you have to be taken our contribution.
No.
And if it is only if anything reply is required, otherwise nothing. But the ultimately, this to be settled in such a way where it's a win-win situation for both of us. We are not going to suffer any hardship.
Heard the Lana Senior Council, so and so for the petitioner. List on so and so first September. Till then, we have 230 matters. See, if it is taken up, it has to finish. Very good. Ready? Yes, sir. Interim order granted earlier, external till instead of later. On 230 interim. Yes, sir. In all the matters, interim order is 16. Till next. No, nothing. No, it will happen. Nothing else. At least that matter will be concluded. No. It will be. 30 matters disposal. 30 matters disposal on the 30 disposal. Signature. ಇನ್ನೊಂದು ಯಾವುದೋ ಒಂದು ಮ್ಯಾಟರ್ ನೋಡ್ಬೇಕಿದೆ ಕೊಡಿ ಇಲ್ಲೇ ನೋಡ್ಬೇಡಿ. You can proceed. You need not wait. No, you need not proceed. Anyway, it will be taken up. Yes, names. I know. So billing, then it is very difficult. The order sheet ಏನಂತ ಮಾಡಿದ್ವಿ? ಇದನ್ನ correct. Petition. 21 filed by Petition. Filed by the respondent due to Correct again. Correct again. But all even otherwise also make it clear. ಒಂದನ್ನ ಮಾಡ್ಬಿಟ್ಟು ಕಳಿಸ್ತಂತೆ ಒಂದೇ ಒಂದು ಸ್ಮಾಲ್ ಒಂದೇ ನನ್ನ ಕೌನ್ಸಿಲ್ ಅನ್ನ ಬರ್ಬೇಕು ಅಷ್ಟೇ ಒಂದು ಮಾಡ್ಬಿಟ್ಟು ಕಳಿಸ್ತೀನಿ ಇವತ್ತಿಂದ ಕೊಡಿ ಅವ್ರೆ ಕೊಡಿ ಅದು ಮಾಡ್ಬೇಡಣ ಕೊಡಿ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬಿಡಿ ಐ ಗಾಟ್ ಇಟ್ ಯಾವತ್ತಿನ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಇದೊಂದನ್ನ ಕಳ್ಸಿರಿ ಚೇಂಬರ್ ಕಳ್ಸಿ ರೀಡು ಮಾಡ್ಬಿಟ್ಟು ಕಳ್ಸಿ Any petitions or nothing? We can see. Any petitions are I think it is urgent, I think. This revision petition is filed by the defendant number 1 in OS number 284 of 2015 on the file of the third additional senior civil judge and JMSC Tumakuru, challenging the order dated 16th June 2022, declined to accept the application filed by the defendant number 1 under order 7 rule 11D of CPC. The relevant facts for the sake of parties refer to their rank before the trial. It is the case of the plaintiff that the plaintiff, it is the case of the plaintiff, it is the case of the plaintiff that the scheduled properties mentioned in the plaint in OS number 284 of 2015 is a joint family property and in this regard, it is further averred in the plaint that the defendants fraudulently obtained the judgment and decree in OS number 98 of 2013 without making the plaintiff as a party in the said proceedings, and accordingly sought for declaration with the declaration that the plaintiff is the absolute owner of the scheduled property, consequentially challenge the judgment and decree in OS number 98 of 2013. The defendants entered appearance and filed written statement. In the meanwhile, the defendant number 1 filed application order 7 rule 11 of CPC, seeking rejection of the plaint. The said application was resisted by the plaintiff. The trial court, after considering the material record, by its order dated by its order dated 16th June 2022, dismissed the application and feeling aggrieved by the same, the defendant number 1 has presented this petition. I heard she so and so, the counsel appearing for the petitioner. So and so argued that the impugned order passed by the trial court requires to be interfered with, as the suit in OS number 98 of 2013 was declared before the Lok Adalat, and therefore he said judgment and decree is to be challenged only by way of writ petition under Article 226 of the Constitution of India, as the judgment and decree passed by the Lok Adalat is an award and therefore cannot be questioned in a separate suit. In the light of the submission made by the learned counsel appearing for the petitioner, I have carefully considered the averments made in the plaint. Undisputably, the plaintiff in OS number 284 of 2015 is not the party in OS number 98 of 2030. It's not a party in OS number 98 of 2030. So the grievance of the plaintiff in OS number 284 of 2015, that the said judgment and decree in OS number 98 of 2013 before the Lok Adalat was fraudulent and is not binding on the plaintiff, as she is not a party to the said proceedings. On careful consideration of the averments made at paragraph 4 and 7 of the plaint, I am of the view that the arguments advanced by the learned counsel appearing for the petitioner cannot be accepted. The trial court, has observed that the suit is set down for conducting class examination of PW1, despite the defendant number 1 took several adjournments. It's also not in dispute that the suit is of the year 2015 and the application filed by the defendant number 1 is after 6 years from the date of institution of the suit. Needless to say that though Order 23 Rule 3 Class A of CPC bars the second suit on the same cause of action and challenging and also challenging the compromise decree in a suit. However, in the present case, the plaintiff in OS number 284 of 2015 is not a party to the proceedings in OS number 98 of 2013, I do not find any acceptable ground to interfere with the impugned order passed by the trial court and any of the law declared by this court in the case of so and so, just a minute, so and so, so and so. It is a well-established principle in law that while considering the application of order 7 rule 11 of CPC, it is the duty of the court to consider the plain averments alone and should not be misguided by the averments made in the written statement. That way of the matter, there is no perversity or illegality in the impugned order passed by the trial court. Accordingly, revision fails. ತರಿಸಿಟ್ಕೊಂಡಿರಿ DRT ಮತ್ತು ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ತರಿಸಿಟ್ಕೊಂಡಿರಿ. ಇವತ್ತಿತ್ತಲ್ಲ ಒಂದು ಮ್ಯಾಟ್ರು, ಅದು ಹೇಳ್ತೀನಿ. ಇದು ಬೇಕಾಗಿತ್ತು ಫಸ್ಟ್ ಸಿ ನಂಬರ್ 8. ಸಿ ನಂಬರ್ 8 ಇವತ್ತಿತ್ತಲ್ಲ, ಅದಕ್ಕೆ ಬೇಕು ಅರ್ಜೆಂಟ್. ಎಂಟಿ ಎಸ್ ಚಾಪ್ಟರ್ ಟುಮಾರೋ ಅದು ತರಿಸ್ಕೊಂಡಿಟ್ಕೊಂಡಿರಿ. ಅದು ನೆನಪು ಮಾಡಿ, ಆ ಥರ ಚೀಟಿ ಇಲ್ಲ. ಇದನ್ನು ಇಟ್ಕೊಂಡಿರ್ತೀವಿ. ಹೌದು, ಸುಮಾರು ರೆಫರ್ ಮಾಡಿದ್ವಿ, ಇದು. ವೆರಿ ಗುಡ್.
Court officer? Court officer? Court officer?
Sir, really?
Madam, serial number 82 ಏನಾಯ್ತು madam?
82 urgent to 7th.
7th. Okay, thank you madam.